I think all in all, it was a great one. We're live now, I think.
Really?
Yeah. Just give us 2 minutes to sort things out.
Assalamu alaikum. I hope you all are doing fine. So, welcome back to our second session that is going to be on commercial arbitration. And this session will be delivered by Ms. Majid. And after this session, we will be having another session that will be on commercial arbitration moves, which will be delivered by Ma'am Khadvita. So, in order to formally introduce Ms. Iram, I would like to invite Ms. Khansa. Over to you, Khansa.
Assalamu alaikum everyone. I hope you all are fine. Thank you so much for joining us. And thank you so much, ma'am, for joining us. She's here all over from India. Ms. Iram Majid is a legal professional with experience of 19 plus years, and she is the director, Indian Institute of Arbitration and Mediation. She's an executive director, Asia Pacific Center for Arbitration and Mediation. She's awarded as the professor of practice by Manipal University, Jaipur, and an adjunct professor in Maharashtra National Law University. She's as well as an honorary director, Lyot Law College, an observer in United Nations Unilateral Working Group 2 in United Nations. As a result of her experiences, she has been honored with several awards such as BIMAC Top 10 Mediators winner in Asia Pacific Awards 2019. She is in Top 100 Lex Falcon Awards 2021. She is as well awarded with AMU Women's Forum Award and 1000 Women Faces of Asia Awards in Legal Awareness and Humans. And lastly, she is awarded with the Best Administration Award of 2023 of APCM. Thank you so much, ma'am, for being with us, and we are really honored to have you. Please start your session now.
Thank you so much, Fransa, for the warm welcome. And I would like to say thanks to Adnan and Ehsan for inviting me for this session. And it's been an honor always connecting to the student and giving back something to the community. So I hope that this session will be useful for all of you. And I could understand what has been told to me by Adnan and Ehsan and Khansa that you people, you are the newcomer or the budding people who are joining, for arbitration, and who have, something in your mind for coming in this field. So I'm happy to take this session, and whatever your question, if you want to ask something while I'm taking session or while I'm telling you about the international commercial arbitration, you can raise your hand, you can ask, unmute yourself, you can ask directly. And if you have questions, if you want to ask in the end of the session, then also you can post to Ahsan or in the chat box or so, then I'll be happy to take it, ahead. And if any of you want to on your camera, that is also something which, I will highly appreciate, because energy is something which I'll be getting from the participants. Otherwise, how much energy I'll be, having after seeing myself, Adnan and Ehsan. That's it. So if I understand it is like 9:30 in your country. So if you will be able to on your camera, it's not something like a mandate, but you can on your camera, then it is good. Otherwise, I'm happy to see Ehsan and Adnan. And if you want to ask any question, please raise your hand. Feel free, because until and unless we will be not asking question timely, if we will be reserving it for the end, then maybe you may not be able to follow beyond certain limit, and you will be stuck with your question. So that is why I always prefer and always emphasize to my students that if you have anything in between, then please ask that then and there. So today's session is with regard to international commercial arbitration. That is something, thank you so much, Shahid. So that is something which is very, very important for all of us to understand what is international commercial arbitration. So within this 45 to 50 minutes, how I am going to divide this session is what is international commercial arbitration. That is one thing. Second thing is why it is important and what is the advantage of understanding international commercial arbitration. Third is how the enforceability mechanism, thank you, Heather, and how the enforceability mechanism will take place once it is international commercial arbitration. That is with regard to the New York Convention. I'll be talking a little bit more. And then also, if suppose you are going to draft international commercial international arbitration clause. So how it is important to understand procedural law, substantive law, law related to arbitration agreement, enforceability law, and also with regard to the institutional rules. And in the end, if time permits, if you want to ask something about your career, if you want to know something how you can make name, fame, and money, definitely money also in this field, so I am happy to assist you. And not only here, this is the beginning, and after this session, if you want to ask anything, you can reach out to me through Adnan or Ehsan. So with this now, if you understood that what we are going to start or what we are going to have in this session, so I would like to begin my session. My problem is that in between, I also keep on asking questions. So please, either you can use chat box to reply or to respond, then it will give, it will be like a interactive session. So rather than having a professing session or being like as if you feel that it is like a recording, somebody is speaking and is like a recording, so it is good to have an interactive session, because when the session are interactive, we learn more, right? So I'll be using English and Urdu also, so it will be bilingual. This is what I have been told. So I'll be using both the language for the sake of more clarity, and whatever you feel, please keep on writing in the chat box, right? So as my intro is being told to you by Khalsa, that my name is Ziram, and I'm practicing not 919, now it's 21 now. That is the old what she has read, that was the old intro. So it's been 21 years, and my mainly my practice is in arbitration and mediation. So mediation is more close to my heart, but practice is more into arbitration. So that is how I'm doing. And so coming to the point now, arbitration. So as we know that yesterday also you must have heard about arbitration, and today we are dealing with international commercial arbitration. So name itself suggests international. Second thing is commercial, and then arbitration. So itself it says international commercial arbitration. I would like to know from you, how many of you know, in the layman's language, if you could raise your hand, if you could, reply in the chat box, international commercial arbitration. What you understood with this, or what you understand with international commercial arbitration? If anybody want to volunteer for this. Yes, Mahim.
Hello, ma'am. Assalamu alaikum. Hope
Walaikum
you're fine.
assalam.
Ma'am, arbitration means that solving a dispute outside the court, but like a court.
Very good. Very good. So Mahin, if I understand correctly, you mean to say arbitration is adjudication whereby you will be resolving the court just like the way it is resolved in court, but it will not happen inside the court because it is outside court settlement or outside court resolution, right? This is what you mean to say, Mahin? If I understand correctly?
Yes, ma'am.
Okay, so that is very good, and I could see few answers also. So arbitration is the method of settling dispute by peace means. So it is by Hajra. So thank you so much. So arbitration is adjudication. So first thing is we have to understand it is not a dialogue. It is not something which we will be resolving through conversation. Here it is an adjudication. So arbitration is an adjudication process whereby we will be resolving our dispute outside the court, not by way of the traditional method, that is about litigation, but outside the court by a neutral third party who will be called as an arbitrator. And the arbitrator will publish an award. So in the court, like they give a judgment, the court and the judges. In arbitration, the arbitrator will publish an award, and that award is considered to be final and binding. Isn't it? So this is what the arbitration is. But when we are talking about international commercial arbitration, so what do you understand by this word international when it integrated with commercial arbitration? What do you think? Yes, Mahim.
Yes, ma'am. Between two states are more than two states, so it became international.
Okay, very good. Very good. Any other answer? Yes, so Sabahat said it involves different countries' jurisdiction. Manahil?
International commercial arbitration basically means when the disputes among companies internationally on the international level are resolved through the arbitration, and the decision, the award is then enforced through the New York Convention. That is called the international commercial arbitration.
Very good. Very good. Very good. Anybody else want to respond? Anybody else want to, contribute? I could see the Kashif has also mentioned international commercial arbitration could be involving dispute between the parties all around the globe. Okay, very good. So the moment you will see there is a word international integrated to commercial arbitration, it itself suggests that something is international now. So that means something is outside the jurisdiction. And so in the layman's language, I'll be giving you a very, very, basic examples, and very, very, in a layman's language, I'll be telling you. So international, or how to determine international or the foreign, that is, the classification is twofold, or it is based on two kind of classification. One is seat based and second is nationality based. So let's say if one of the person is from Pakistan, or let's say one of the person is from Pakistan and the other person is from India, or let's say Indonesia, then that kind of arbitration will be considered to be the international commercial arbitration, whereby the parties who are from the different national, or the party who involve into the contract or who involve into that dispute belongs to different nation. The nationality is different. That is one way of one way of understanding the classification. Second is when the arbitration is not seated in Pakistan, or it is seated outside Pakistan. That arbitration is also considered to be the foreign arbitration when it comes to the recognition of the, and it will come in Pakistan under the recognition of foreign award by way of New York Convention. What is New York Convention, Aura? That I will be, taking side by side after a few minutes. So this is what international. So the international is, as I told you, number one, the most basic understanding is by the nationality. So let's say one company involved in the contract belongs to Pakistan, other company involves in the contract belongs to outside Pakistan. So that is how this kind of, if the party entered into a contract and they say that in this contract, if any kind of dispute arises, then that dispute will be resolved by arbitration. And if there is a dispute and then they want to resolve it, that kind of dispute will be considered to be an international commercial arbitration. So that will be considered to be the international dispute, and it will come or covered by international arbitration or international commercial arbitration. So that is the layman's language, in the most basic understanding I could have give you. Second thing is that if suppose there is an international commercial arbitration, I would like to understand from all of you, because we are now coming up into this regime, and it is very, very important for all of us to understand this in a deeper manner. Not only the basic meaning, but from the basic to advanced we will be going. So I would like to understand from all of you that if suppose in any dispute or any contract which are cross border, or a nationality is from outside India, let's say if they are involving in a contract and tomorrow there will be a dispute which arises in between these two parties, how they will be resolving if it is a litigation. So they will be going to the court. If suppose they will be going to the court, so either it is let's say if the party is from Indonesia, one party is from Pakistan, so either they will be going to Pakistan or either they will be going to Indonesia court. So let's say Indonesian court has given a judgment in that scenario. So how they will be enforcing that judgment? Can anybody give me an idea about it? अगर आप लोग समझ नहीं पाए हैं तो मैं दोबारा बताती हूँ कि एक डिस्प्यूट और एक कॉन्ट्रैक्ट ऐसा है जो दो कंट्री के बीच में हुआ। एक कंट्री पाकिस्तान है और एक कंट्री इंडोनेशिया है। इंडोनेशिया उन्होंने आर्बिट्रेशन रिजॉल्व करने के लिए आर्बिट्रेशन नहीं लिया था, लेकिन उन्होंने लिटिगेशन से किया था। अब जब लिटिगेशन से होगा, या तो वो पाकिस्तान में होगा या वो इंडोनेशिया में होगा। अब अगर वो इंडोनेशिया में होता है और जब इंडोनेशिया में होता है तो वो लिटिगेशन के थ्रू होता है, तो आप बताएंगे कि आउटकम जजमेंट होगा, जजमेंट को कैसे इन्फोर्स कराएंगे?
अस्सलाम वालेकुम मैम।
वालेकुम सलाम अली।
मैम जो कॉन्ट्रैक्ट होता है कमर्शियल कॉन्ट्रैक्ट है तो उसमें गवर्निंग लॉ जो होगा उसमें होगा। लेट्स से उन्होंने गवर्निंग लॉ रखा है कि पाकिस्तान का होगा, अगर उन्होंने रखा है तो वो पाकिस्तान को लॉ इम्प्लीमेंट होगा। अगर उन्होंने इंडोनेशिया का लॉ गवर्निंग लॉ रखा है कॉन्ट्रैक्ट के अंदर जो एसेंशियल होता है कमर्शियल कॉन्ट्रैक्ट का, तो फिर इंडोनेशिया को फॉलो होगा। और अगर उसमें वो गवर्निंग लॉ
मान
नहीं
लीजिए वेरी वेरी गुड अली, मान लीजिए कि हमने इसको इंडोनेशिया के लॉ से करा और इंडोनेशिया के कोर्ट ने इसका जजमेंट दे दिया। अब वो जजमेंट हमको इन्फोर्स करना है, तो हम कैसे करेंगे जजमेंट को इन्फोर्स?
मैम दैट आई हैव नो आइडिया।
तो जजमेंट के इन्फोर्सिबिलिटी के लिए आपका सिविल प्रोसीजर कोड होता है, एंड सिविल प्रोसीजर कोड में आपका रेसिप्रोसिटी ऑफ जजमेंट भी होता है, रेसिप्रोसिटी ऑफ ऐसे होता है। देन हाउ यू विल बी डूइंग इट, दैट इज अ डिफरेंट काइंड ऑफ स्टोरी। इट्स नॉट इजी। if it is not easy, who will be the sufferer? नुकसान किसको होगा? अगर आपके पास आज हाथ में आपके एक जजमेंट है और जजमेंट आप इन्फोर्स नहीं करा सकते, नुकसान किसका होगा?
मैम ऑब्वियसली जिसके साथ ब्रीच ऑफ कॉन्ट्रैक्ट है उसका होगा नुकसान।
Very good. So that means parties are the sufferer, right? And the laws and procedure are only for the party. So the main idea behind this arbitration is that the party should not suffer or the user should not suffer. और the user suffer कर रहे हैं तो वो लोग क्या नहीं करेंगे फ्यूचर में? They will not enter into the contract. Which kind of contract? International contract. And then it will hamper the business. So that means if we'll go down to the root, then we will be able to understand that it is international commercial arbitration is to ease the business, and the benefit is to the community, the business community. So tomorrow when the party, they are trying to enter into a contract that is a cross-border contract or the cross-border business or any kind of investment, so they feel they will think that okay, tomorrow we are entering into the contracts and there will be a conflict because disputes are inevitable. So how to resolve it? If there will be a proper mechanism by which you know that if you will be resolving the dispute resolution is very, very easy by arbitration. We have a mechanism that is arbitration, and resolution of this dispute is very, very easy through arbitration. And once we have an arbitral award, also the enforceable mechanism or enforceability of the arbitral award is also very easy. Then the parties, they are encouraged to enter into a contract because tomorrow they have no inhibition that tomorrow there will be any kind of dispute, so that dispute will not be resolved. So they have a confidence that tomorrow if any dispute, we can resolve it in our own style, in our own way. So that is how the international commercial arbitration gives a kind of a confidence in the business community that we can enter into a contract and we can do business, and it is the business community to go for business. So globalization has led to the need for an efficient international dispute resolution system. Parties might be unfamiliar with the foreign legal system, might face language barrier, and could be unfairly disadvantaged if they're required to litigate in a foreign country. So that is what I told you. If suppose the country has to litigate in the other country, that will be something you have to follow their process. But in arbitration, I will be covering that. So what is governing laws, what is lex fori, that is the curial laws or so. I'll be coming to that. But I am now on this, that why ICA, that is international commercial arbitration, is important. What are the benefit of it and how it is becoming very common. So the court judgment have a territorial limitations. Foreign judgments may be recognized based on bilateral or multilateral treaties or understanding or unilaterally without an express international agreement. And believe me, if you say that we have a bilateral arrangement, then with the bilateral arrangement, we can have a recognition of judgments also. So that is also not an easy task if you have a bilateral or multilateral treaties. So international arbitration is the preferred method for resolving the cross-border disputes. The neutrality it offers, together with the relative ease of the enforceability of the award, can make it more attractive forum for the dispute than litigating in the contracting parties in the national court. So the nationality of the arbitration extend to the award. So the award of a London seated tribunal will be regarded as an English award. So this is the significant which comes to the enforcement. So international arbitration has been chartered as a formal dispute resolution process and has established a sophisticated procedure and enjoy the benefit of a well-developed international legal framework, which is largely based on the convention. So now, if you understand that what is the importance of international commercial arbitration, it is for the for the for the business community, so that they can enter into a cross-border dispute without having any kind of inhibition. That is one thing. Second thing is, it is time effective. If suppose you will be going for the litigation in the cross-border dispute and the party will have no confidence, आप कैसे resolve करोगे, कैसे करोगे, कौन से कोर्ट में किस लॉ से करोगे, आप एक प्रोसीजरल कॉम्प्लेक्सिटीज में फंस जाओगे. लेकिन आर्बिट्रेशन में क्या है, इट इज लाइक अ टेलर मेड सूट. आप जाओगे, आप एक टेलर को आपका कपड़ा देते हो, आप कहते हो इससे डिटेलिंग कर दो, इसकी ऐसा बटनिंग कर दो, यहाँ पे ऐसा कर दो, जैसा आप वैसा कहते हो, आर्बिट्रेशन में आपको वैसा होके मिलेगा. द वे यू सेड के आई वांट दैट द आर्बिट्रेशन का ना तो इंडिया में हो ना इंडोनेशिया में हो, हम चाहते हैं आर्बिट्रेशन सिंगापुर में. So that is what you call seat, that is jurisdiction. So you can fix the jurisdiction. You say, we want Iram Majid madam as an arbitrator. You can fix Iram as an arbitrator. You say, we would like to do it in morning time. Okay, you can do it in the morning time. We want to complete the entire arbitration within 9 months. So whatever you want, it is a party-centric process. Mahin, you want to ask something?
Yes, ma'am. Ma'am, you make us understand the international commercial arbitration with regard of two aspects. One was based on the nationalities, and other one was that if we resolve the dispute at some other country, that was something.
ऐसा होता है इसमें कि आर्बिट्रेशन में एक बहुत अच्छा मैकेनिज्म ये होता है कि जब आर्बिट्रेशन में आप जाते हैं, आप ना सीट फिक्स कर सकते हो. सीट का मतलब ज्यूरिसडिक्शन. आर्बिट्रेशन में ज्यूरिसडिक्शन का मतलब ये नहीं है कि डोमिसाइल ऑफ द पार्टी या वेयर द पार्टीज आर वर्किंग. इसका मतलब ये नहीं. यहाँ पे मतलब ये है कि आप अपनी जगह जहां पर आपको आर्बिट्रेशन करना है, आप वो खुद फिक्स कर सकते हैं. सो सपोज इफ आई एम इन इंडिया, यू आर इन पाकिस्तान, एंड वी एंटर्ड इनटू अ कॉन्ट्रैक्ट, एंड इफ यू से कि इरम, so this kind of arbitration will be considered to be the international arbitration if it either it is happening in India or either happening in Pakistan. That is international. The second classification is, let's say if we are doing it outside Pakistan, so or the two people who are from the different country, and they concluded the arbitration somewhere and they come to your country for the enforcement. So that is also coming as a foreign award. That will be a foreign award. So one is the award which is rendered in Pakistan, जो आपके यहाँ दिया जाएगा, चाहे वो आपकी नेशनलिटी उसमें आपकी हो या यहाँ की हो. और दूसरा ये कि नेशनलिटी कहीं की भी हो, चाहे पाकिस्तान के दोनों लोग हों, लेकिन वो रेंडर करा गया किसी और जगह पे. सो दैट इज समथिंग विच इज बीन रेंडर्ड आउटसाइड योर कंट्री. तो दो तरह की क्लासिफिकेशन हो गए कि जहां तो आपने सीट फिक्स करी, जहां का आपने ज्यूरिसडिक्शन फिक्स किया, क्योंकि आर्बिट्रेशन में आप ज्यूरिसडिक्शन फिक्स कर सकते हैं. और दूसरे कि जहां या तो आपकी नेशनलिटी अलग अलग हो दूसरी कंट्री की. तो दो तरह की क्लासिफिकेशन हो गए. ठीक है? आर यू गेटिंग माय पॉइंट? And why you will be not going, see, you can go to mediation also, you can go to negotiation also. So suppose if you want to go for these are the mixed mode. So let's say if I'm entering into a contract that is an international contract, let's say it is for the investment, and I understand that in this contract there will be a dispute also. So what I'll do, I will try to formulate, or I'll try to draft a contract that is an arbitration contract with the mixed mode. So what I'll do, first the party will try to settle the dispute by negotiation. If it fails, then they will go for the mediation. If mediation also fails, then the party will go for the arbitration. This is the kind of tier clause also, and it is called the mixed mode also. So AMA protocol also, that all together a drafting of arbitration clause, if you will fix Adnan another class. So I'll be happy to take how to draft an arbitration clause in international cases. So that is altogether a different thing. I'll be coming to a smaller. I'll be touching that also. But here, if you all understood that, what do you understand by international commercial arbitration? What is the benefit? So the benefit is to encourage the international business. So that means it is for the business community, right? Now, second question is, if it is for the business community, it is also user centric. It is also very important and very easy and smoothly. The mediation arbitration can be happen, or the enforceability is also possible of the arbitral award. So let's say party A and party B. Party A is from Pakistan, party B is from Indonesia, and there is a dispute, and they said that we want to settle this dispute in Singapore, and they fixed the seat of arbitration or the jurisdiction of arbitration in Singapore. So wherever the award is rendered, the award is considered to be the baby of that seat or the citizen of that seat. So the award which is rendered in Singapore is considered to be the baby of Singapore or the citizen of Singapore. So it will be the entity or the citizenship of the Singapore will be applicable on this award. And now let's say tomorrow you want to enforce this award. You want to enforce this award and you feel that this person, let's say the Indonesian person win this award in this arbitration, and now they have to execute this in Pakistan. So the award is rendered in Singapore. The person who belongs to Indonesia having the award in his favor, and this person want to enforce it in Pakistan. So is it easy or difficult? Is it easy or difficult? Are you following what I'm saying? Difficult. Why, Eunice, it is difficult? Can you tell me why it is difficult? Can anybody tell me why it is difficult कि एक अवार्ड जो है हमने सिंगापुर में दिया क्योंकि हम कर सकते हैं ये आर्बिट्रेशन में, हमने सिंगापुर में उस अवार्ड को रेंडर कराया। अब वो अवार्ड जो है वो सिंगापुर का बेबी होगा, सिंगापुर का सिटीजन होगा। नाउ the person who is in Pakistan, this award is against that person, and the person who is in Indonesia, this is in favor of that person. Now the person who is in Indonesia, he want to execute it, this award. It's not just a piece of paper, he want to execute. So how that could be executed? So I get some answers. So it shall be executed as a foreign judgment. Guess easy, I guess, because the seat was decided by both the party, should be binding on both the party. Easy as award is binding on both the party. No proper machinery to enforce the international law. Any other answer? Okay, Kashif. Arbitral award are not binding. Okay. So let me go back to more basic. So arbitral award is binding. Yes, Mahesh?
Ma'am, I have a doubt regarding the enforcement of foreign arbitral awards. As you mentioned that foreign arbitral awards is binding upon the parties, is it like binding only to the signatories to the New York Convention?
That's
or
what I am coming. That's what I am coming. I just want to name the convention because I want to understand from them that whether it is difficult to enforce. If it is difficult, so how it will be enforceable? So definitely, Mahesh. So I'll be coming and touching the New York Convention now. So I want to, have a brainstorming on this. So I get very interesting answers. So for this reason, let me tell you that arbitration award is final and binding. All the students, please keep this in your mind. Arbitration award is final and binding. So it will be binding on both the parties. But the problem is how to enforce. How to enforce it. So when it comes for the enforcement, suppose if it is an arbitral award, belong to different country, you want to enforce it in Pakistan. So the most important thing is that there is a need of a convention. And there is a convention. The convention name is New York Convention. So it will be enforceable by way of this convention. Anybody who is here who knows about New York Convention, or have you heard about New York Convention? Anyone? New York Convention? Okay. So New York Convention is the convention which is being made in 1958 by United Nations, that is UNCITRAL. That is a body of the United Nations, that is UNCITRAL. And they have deliberate there and they discuss that there should be a uniformity or the uniform principles of of enforcement of arbitral award. Otherwise, what is the purpose of being into arbitration? जब हमारा arbitration में हम जा रहे हैं, arbitration का award हमारे किसी काम का नहीं है, then why we should be going for the arbitration? So then there was a discussion, and the outcome of the discussion is the New York Convention. So this is the convention, or it is a treaty by which the country who will become the signatory of this convention, all the country, they will bind, or they will be following the New York Convention. And out of this, the consequence is that anywhere in all the signatory country, the award is enforceable. So it is not only in Pakistan. Let's say the person who is in Pakistan, his property is in India, or whose property is in Bangladesh, whose property is in London. So that can be enforceable even in those countries which are signatory to New York Convention. It is not only your country or my country. It can be enforceable in all the countries who are signatories. So this is very powerful convention. Very, very powerful convention. If I told you the date is 1958. So 1958, if you remember that when India and Pakistan was not disintegrated, in 1947, it's become two different countries. So, but both the country followed 1940 Act, 1940 Act of Arbitration and Conciliation Act. So that Arbitration Act of 1940, sorry, Arbitration Act 1940. So, so that was in use by both the country, right? Just after 18 years, the New York Convention came into existence, and the reason is that the New York Convention should give the boost to the international business, and it will give the momentum to the international business, so that the party who are entering into a contract should not be hesitant, should not have any kind of inhibition to enter into a contract, that tomorrow if there will be a dispute, how will resolve it? You will resolve through international commercial arbitration. Okay, if I will be resolving through international commercial arbitrations, then how I will be enforcing or executing the arbitral award? So you will be having a kind of convention by which you can enforce it. So that is why it came. But that was not the only convention which we had in 1958. In 1923, 100 साल पहले, there was a convention. In 1927, 100 साल से थोड़े से साल कम, we also had a convention, that is Geneva Convention and Geneva Protocol. The reason was, and the purpose of those conventions was the same, that the convention which we have now, the New York Convention. But those conventions did not get a kind of momentum which New York Convention took, because those conventions were not very user friendly. अगर आप उनको दोनों को कंपेयर करेंगे आज न्यू यॉर्क कन्वेंशन को और जेनेवा कन्वेंशन को, तो कुछ कुछ चीजें सेम है, एज इट इज ले ली गई हैं, सेम है, लेकिन बहुत ही ज्यादा फ्रेंडली नहीं है. और उस टाइम पर उसके 43 कंट्री ने रेटिफाइड किया था. तो न्यूयॉर्क कन्वेंशन में एक क्लॉज ये भी आया कि जो कंट्री न्यूयॉर्क कन्वेंशन को रेटिफाइड करती हैं और इसको सिग्नेटरी होती हैं, और वो जेनेवा कन्वेंशन की भी सिग्नेटरी होती हैं, तो उनके ऊपर जेनेवा कन्वेंशन नहीं चलेगा, बल्कि न्यूयॉर्क कन्वेंशन उनके ऊपर अप्लाई होगा. ये बात भी आती है आर्टिकल 7 में न्यूयॉर्क कन्वेंशन में. फिर हमने रिसर्च करके ये देखा गया कि कितनी कंट्री जो थी वो जेनेवा कन्वेंशन के पार्ट थी, और कितनी कंट्री वहां से आई जो न्यूयॉर्क की पार्ट है, न्यूयॉर्क कन्वेंशन का पार्ट है. क्या कोई कंट्री ऐसी बचती है जो न्यूयॉर्क कन्वेंशन का पार्ट नहीं है, सिर्फ जेनेवा कन्वेंशन का पार्ट है, जिससे कि हमें ये मालूम पड़ सके कि जेनेवा कन्वेंशन आज भी यूज में है या नहीं है? तो मालूम ये पड़ा कि जितनी भी कंट्री जो जेनेवा कन्वेंशन का पार्ट थी, उसके बाद वो सब के सब, जिनके कंट्री का नेम अलग था, या किसी के रिपब्लिक, या वो बाद में रिपब्लिक बनी, या वो कॉलोनीज थी उस टाइम पे, नेम चेंज करके वो आज सब न्यूयॉर्क कन्वेंशन का पार्ट है, न्यूयॉर्क कन्वेंशन का सिग्नेटरी है. दैट मींस जेनेवा कन्वेंशन इज रिडंडेंट नाउ. तो दैट इज व्हाई इट इज आउट ऑफ द क्वेश्चन. हम उस पर बात ही नहीं करेंगे, हम बात करेंगे न्यूयॉर्क कन्वेंशन पर. न्यूयॉर्क कन्वेंशन को इंडिया ने 1960 में रेटिफाइड किया था. I have no idea that New York Convention is being when it was signed by Pakistan. That I have no idea. But the country who signed this New York Convention, आप देखें 174 country have signed New York Convention so far. 197 countries are in the world. हमारी पूरी दुनिया में 197 कंट्रीज हैं, 174 कंट्रीज ने न्यूयॉर्क कन्वेंशन साइन कर दिया. अगर आप इसको एक ब्लू कलर देना चाहो न्यूयॉर्क कन्वेंशन को, पूरी दुनिया जो है आपको ब्लू कलर की दिखेगी. तो वेरी फ्यू कंट्रीज आर लेफ्ट हु हैज नॉट been signed this convention, that is how the arbitration become common, and it takes a momentum. And then UNCITRAL, they also said, and okay, now we need to have a uniform law. And then in 1985, they come up with the uniform model law that is called UNCITRAL Model Law on Arbitration. In 1985, India copied it after 1940 Act. 1996 Act we have, and that is a copy cut paste of UNCITRAL Model Law. So that is how it is the international law. And if you see anywhere in the world who has copied or who has come up with the new law after 1985, everyone has a uniform law. If I am teaching you UNCITRAL model law, if I teach you Indian Arbitration Act, if I teach you anywhere, so it is same for all over the world. That is why you have a very, very bright opportunity, a career opportunity. It's a global profession in arbitration. So if you read UNCITRAL model law, if you read anywhere, Arbitration Act of any country, that means you are reading the arbitration procedural law of the entire world, because it is the uniform practice. So that is the benefit. So suppose if you say Iram Majid sitting in Indonesia or sitting in India, Adnan sitting in Pakistan, Ehsan sitting in London, Mahesh sitting in in let's say in Hong Kong, everyone understand it is the same and uniform practice. If suppose all of us enter into a contract whereby, let's say, seat is fixed Malaysia, we can fix a seat in Malaysia. That is the comfort we have, the comfort we can have. And once it is seat in Malaysia, and now we know the in US, the property is in US, and my property is in US, and award is against me. If all of you want to enforce it, you can go to US, because US is also the signatory to New York Convention. So that is a ease, that is a benefit, or that is a kind of support system which has been given by the New York Convention for the business community. तो ये सारा का सारा जो है, अगर आप देखें, सिर्फ और सिर्फ बिजनेस के लिए है, बिजनेस कम्युनिटी के लिए, इसलिए इसको कमर्शियल में ऐड किया गया. तो ये बेनिफिट है इसके कि आपको न्यूयॉर्क कन्वेंशन मिलता है. अगर आप डिस्प्यूट कोर्ट में लेके जाएंगे, आपका बायलेटरल हो अरेंजमेंट, आपको रेसिप्रोसिटी जजमेंट की करनी पड़े, आपको बहुत बहुत मुख्तलिफ तरीके की आपको इसमें दुश्वारियां आएंगी, आप नहीं कर पाएंगे उसको किसी तरीके से भी, बहुत बहुत साल लगेंगे. So that is how arbitration become very, very popular and very, very common. आज हर दूसरा आदमी जो है, they want to sorry, they want to get the practice of arbitration, and that is why I am also into this practice. So that is how you. Now I told you about international commercial arbitration. I told you about the importance of international commercial arbitration, and I told you about the treaty or a convention, that is New York Convention. It is very, very important. 1958. ये याद रख लेना. Now I am coming to the thing is, suppose if you need to understand international commercial arbitration, so what are the few things which you keep in your mind? Number one, what all the laws which will be applicable if you are dealing in a dispute. या आप अगर एक कॉन्ट्रैक्ट में एक क्लॉज डालते हो, तो उस क्लॉज में आपको चॉइस जो होती है लॉ डिसाइड करने की या सीट डिसाइड करने की, वो कैसे कैसे हो सकती है. दिस इज व्हाट आई वुड लाइक टू टेल यू नाउ. If the previous thing are clear to all of you, if you have any doubt, please ask me. Feel free to ask. Otherwise, I am moving towards the understanding of. Yes, Mahesh. Mahesh, your turn. Yeah.
Ma'am, actually, if there is an award against some particular different countries are parties to the arbitration, and there is an award, and the same award has not been enforced, will it have implications in the United Nations, or how will the award be enforced?
How the award will be enforced? So yeah, the very simple answer is, let's say, you first of all you have to identify that whether the award is rendered where, so that country is signatory to New York Convention or not. तो कनेक्शन जो होगा ना, वो सीट का और जहाँ पे enforceability होगी वहां का कनेक्शन होना बहुत जरूरी है आपस में. Those two countries should be the country who signed New York Convention. Let's say I am from Uganda, you are from let's say somewhere else. We both are from the non-signatory countries, but we select the seat that is Singapore, that is
Signatory.
And you know that the person who is in Uganda, his asset is in London. London is also signatory. So the enforcement country and the country where it is rendered, there should be a connection, that both the countries should be convention countries. Now the thing is, suppose if you will be going for the enforcement, let's say you are going for the enforcement in London. So how the court will enforce it? Or let's say you come to India. So how the Indian court will enforce it? So the first thing is Indian court will enforce it under the New York Convention. So enforcement of the New York Convention, there will be a part. So we have part 2 in Indian Arbitration Act. The part 2 deals with international commercial arbitration. So it will be dealt by New York Convention. That is one thing. But how you will enforce it? You will be filing an application in the court under Arbitration Act. So by way of your Arbitration Act or by way of your arbitration, that is a procedural law. Arbitration is a procedural law through which you have to file an application for the enforcement in that particular country. Are you getting my point? So I hope that I answered your question.
Yeah, thank you.
So there is no involvement of UN after that. So UN is the body who gave this convention. UN will not come, in your day-to-day affair. The enforcement has to be done by way of Arbitration Act, and Arbitration Act of that particular country where you are going for the enforcement. So let's say you are seeking enforcement in India, then Indian Arbitration Act. If you are seeking enforcement in Malaysia, then it will be under Malaysian Arbitration Act. So that country law will applicable, isn't it? So if everything is clear up to now, so so can we move ahead? Okay. So now the other thing which I would like to highlight here is that what all the laws you need to understand, or what are the law involved in arbitration. So if suppose you are going to understand the arbitration, so there are 2 or 3 set of laws which you need to understand. Number 1 is, tell me, what kind of law should be involved in arbitration? Or let's say, if suppose there is a person who committed theft, right? So how the punishment will be given to that person? If he has committed theft, इसने चोरी करी है, तो उसको आप कहाँ सजा दोगे और कैसे सजा दोगे? Yes, Mahesh.
Ma'am, so theft doesn't falls under the arbitration, right?
मैं आपसे वो बात आप मुझे बस इसका जवाब दे दिए, आप थेफ्ट को कैसे आप आगे करोगे?
Basically, approach the courts, ma'am.
Approach the court, and somebody has said CRPC and PPC allow it. Okay, so that means there will be either IPC, that is Indian Penal Code, or Pakistan Penal Code. So there will be provision for that punishment, right? But how to grant bail and how to do it, it will be under Civil Procedure Code. So that means there are 2 kind of things or 2 kind of laws which are involved in any dispute. One is substantive law and other is procedural law. So for the narcotics, let's say the dispute is for the narcotics, so it will go under narcotic law, that is substance, and how to do the arrest, how the conviction has been done, how the accused can obtain the bail also. So that will be through CRPC. That is a procedural law. Similarly, in arbitration also there will be a dispute with regard to the substance. So that is what the substance of the dispute, that is substantive law. Let's say it is a sale and purchase or a kind of contract. So that will, for that the contract law will be applicable. The contract law is a substantive law. and how to deal that contract, or how, if a dispute arises, how to deal with that dispute, that is arbitration law, and that is procedural law. So what is the scope of substantive law and what is the scope of procedural law? So we'll start with first with the procedural law. So what is the scope of procedural law? What do you think the procedural law and how the procedural law deal with the entire dispute? What and how it should be governed? Procedural law. What procedural law provides? भाई सारे लोग लॉ के स्टूडेंट हैं यहाँ पे, मुझे दिख रहे हैं. Procedural law governs jurisdiction. Very good. Procedural law governs jurisdiction. So if suppose there is a procedural law will decide that which court, what is the territorial jurisdiction and all those things. Very good. What else? What else? Yes, Manahil.
Ma'am, the procedural law basically tells us about the jurisdiction, the process, the method, and or how to be defined, as well as the powers and the authority of the court.
Very good. Very good. So that means, let's say in arbitration. So arbitration law is considered to be the procedural law, right? So when arbitration law is a procedural law, so, and it also known as lex fori, it also known as curial laws, right? So what do you think that the scope of arbitration law? Is it a procedural law? So what is the scope of arbitration law? Tell me. Who will tell me that? What is the scope of procedural law or the arbitration law? भाई सोचो और बताओ. यस माइन. 2-3 बच्चे बता रहे हैं भाई, ये तो गलत बात है. यस माइन.
Ma'am, each country or each state make different laws of related to procedure. So I
Yes.
think that we will follow the country's procedure law, whatever it is.
So let me tell you now from the arbitration point of view. The procedural law of arbitration is sometimes referred to as an lex arbitri curial law, and the procedural law that will apply depend on the place or the seat of arbitration. That is the most important thing. And another thing is the procedural law determines to what extent the local court will be involved in the process. For example, any formality to be complied with, the extent to which the arbitration agreement excludes the court jurisdiction, how much autonomy and discretion the party have in choosing the arbitral procedure, what support the court will give to the arbitration, whether the decision of the arbitral tribunal can be appealed and what time scale it will be, and enforceability of the award. Everything can be determined or should be determined or will be determined by procedural law. And when it comes to substantive law, the substantive law is the law governing the subject. Somebody has said that the governing law of that country. So the governing law is nothing but it is a substantive law. Substantive law means the law which applies to the substance or the subject matter of the dispute. So the substantive law is the governing law, the subject and merit of the dispute. It's sometimes described as applicable law also, or the governing law, or the law of the contract. So तीन चीजें इसमें आती हैं, आपका applicable law, governing law और the law of the contract. ये सारे के सारे आपको अलग अलग जगह देखने को मिलेंगे. आप कहेंगे ये मैडम ने substantive law बताया था, लेकिन arbitration substantive law लेके नहीं कहा जाएगा, सो कहा जाएगा applicable laws, governing laws या law of the contract. In the most jurisdiction, the party are free to choose the law that will apply. An arbitration agreement will generally set out its governing law at the outset, and the parties' right to do so is enshrined in the various international conventions and institutions. And in the alternative, where the party have failed to agree, let's say आपने agree नहीं किया है कि कौन सा governing law लगेगा, then the tribunal will choose the law applicable to the depending on the facts of the case at hand, using criteria of such as selecting the law with the closest connection to the dispute. So substantive law हो गया आपका, आपको उसकी समझ होना बहुत जरूरी है जब आप arbitration में जाएंगे. तो दो तरह के law जो हैं वो main है. Number 1 is procedural law, number 2 is substantive law. Substantive law हो गया आपका law जो कि आपका dispute है contract का, लेट्स से ब्रीच ऑफ द कॉन्ट्रैक्ट. So the breach of the contract is a dispute. So that is the substantive part of the contract, and for that reason the law of contract will be applicable. And the second is, अगर वो dispute होती है breach की और आपने उसको decide करना है arbitration से, then the procedural law will be the law of arbitration. ठीक है. अब ये दो लॉ जो हैं ये आपको हर कोई बताएगा, बिकॉज दीज आर द ब्रॉडली यूज्ड लॉ इन आर्बिट्रेशन. बट देयर इज थर्ड लॉ आल्सो दैट मेनी पीपल दे फील दैट बिकॉज आर्बिट्रेशन एग्रीमेंट. अब मैं एक और चीज पर आ रही हूँ, इसको मैं बाइफरकेट करूंगी. आर्बिट्रेशन एग्रीमेंट जो है उसमें एक चीज होती है दैट इज कॉल्ड सेपरेबिलिटी. ठीक है, मैं इसको अभी यहीं से मैं इसको लेके जाऊंगी, लेकिन पहले मैं इसको खत्म कर दूं. दैट आर्बिट्रेशन एग्रीमेंट है, आर्बिट्रेशन एग्रीमेंट जिस भी कॉन्ट्रैक्ट में आ गया, कहा यह जाता है आर्बिट्रेशन एग्रीमेंट का किसी भी कॉन्ट्रैक्ट में होने से दो कॉन्ट्रैक्ट बन जाते हैं. Those are two contracts and they have two legal existence. So that means that a separate legal existence, and the person who entered into an arbitration clause, that is a part of the principal contract. That means you entered into two contract. आप दो कॉन्ट्रैक्ट में आए हो. सो दैट मीन्स देयर इज अ सेपरेबिलिटी. द कंसेप्ट ऑफ डॉक्ट्रिन ऑफ सेपरेबिलिटी, आर्बिट्रेशन एग्रीमेंट इज कंसिडर्ड टू बी अ सेपरेट एग्रीमेंट ऑल टुगेदर. तो चाहे आपका प्रिंसिपल कॉन्ट्रैक्ट जो मेन कॉन्ट्रैक्ट है वो फ्रस्ट्रेट हो जाए, चाहे वो टर्मिनेट हो जाए, चाहे वो इम्पॉसिबल हो परफॉर्म करने के, लेकिन आपका आर्बिट्रेशन एग्रीमेंट जो है वो सर्वाइव करता है, बिकॉज वो आपका और टर्म्स से इंडिपेंडेंट कॉन्ट्रैक्ट माना जाता है. ठीक है, तो अगर वो इंडिपेंडेंट है तो यहाँ पर एक थ्योरी ये भी आती है कि भाई जब उसका लीगल एग्जिस्टेंस सेपरेट है आर्बिट्रेशन एग्रीमेंट का, तो हमारे पास एक तो सब्सटेंस हो गया मेन कॉन्ट्रैक्ट का, एक हमारा हो गया प्रोसीजरल लॉ, तो थर्ड लॉ हो गया द लॉ एप्लीकेबल टू आर्बिट्रेशन एग्रीमेंट. That means the law which applies on the arbitration, because arbitration agreement तो अपने आप में एक अलग एग्रीमेंट है. तो एक तो आपका कॉन्ट्रैक्ट हो गया बिजनेस का, एक आपका हो गया उसका सब्सटेंटिव लॉ, एक आपका हो गया कि हाउ एनी डिस्प्यूट इन दैट बिजनेस कॉन्ट्रैक्ट हैपेंस दैट हम रिजॉल्व करेंगे थ्रू आर्बिट्रेशन, वो आपका दूसरा हो गया. लेकिन आर्बिट्रेशन एग्रीमेंट इज आल्सो कंसीडर्ड टू बी अ सेपरेट कॉन्ट्रैक्ट ऑल टुगेदर. इट इज अ सेपरेट एग्रीमेंट, एंड फॉर दैट रीजन यू कैन डेजिग्नेट अ थर्ड लॉ और एनी लॉ विच द पार्टी वांट टू डेजिग्नेट. वो कहते हैं कि हमारा आर्बिट्रेशन अगर होगा तो सीट होगी हमारी सिंगापुर में. ठीक है, पार्टी है मलेशिया की और इंडोनेशिया की, सीट होगी हमारी सिंगापुर में, और हमारा सब्सटेंटिव लॉ होगा हमारा इंग्लैंड का, और हमारा प्रोसीजरल लॉ होगा जहां की सीट है वहीं का होता है. ये याद रखिएगा, दोनों का पर्पस एक है, सीट का पर्पस भी एक है और प्रोसीजरल लॉ का पर्पस भी एक है. दोनों कोर्ट्स को गवर्न करते हैं, जुरिडिक्शन डिसाइड करते हैं. तो हमारी सीट कहाँ की थी? सीट थी हमारी सिंगापुर की. सिंगापुर की थी ना या मलेशिया की थी? भाई मैं चेक कर रही हूँ तुम लोगों को, सो रहे हो जाग रहे हो? कहाँ की थी सीट? हाँ शाबाश, मैं भूल जाती हूँ असल में, इतनी बार बताते. तो सीट इज फ्रॉम इन सिंगापुर. तो प्रोसीजरल लॉ कहाँ का होगा? प्रोसीजरल लॉ विल बी फ्रॉम सिंगापुर. ठीक है, वेरी गुड, प्रोसीजरल लॉ भी सिंगापुर का हो गया. अब पार्टी कहती है कि हमको सब्सटेंटिव लॉ लेना है. हमने कहाँ के लिए सब्सटेंटिव लॉ कहाँ का लिया था? बताओ बेटा. लंदन का. वेरी गुड रजा, हमने लिया वहां का लंदन का सब्सटेंटिव लॉ. हमने आर्बिट्रेटर लिया इंडिया का इरम माजिद. ठीक है, ले सकते हैं, वी कैन डू दैट. अब हमारे पास एक चीज और है, दैट इज आर्बिट्रेशन एग्रीमेंट. क्या हम कह सकते हैं कि आर्बिट्रेशन एग्रीमेंट पे द लॉ ऑफ हांगकांग विल अप्लाई? कैन वी से दैट और नॉट? Yes, we can. So that is how there is a third law that applies in arbitration. जो कि बहुत बहुत important है. If you want to make your arbitration clause complicated, you can designate the third law that is considered to be the law applicable to arbitration agreement. You can do that. And the fourth important thing which you have to understand is, अब मैं इसको थोड़ा सा आगे एडवांस पे ले जाऊं 2 मिनट के लिए. बच्चों जल्दी बताओ, can I take this to little advance? ओके, मजा आ रहा है? तो चलो उसको थोड़ा सा एडवांस पे लेके जाते हैं. अब ये मान लो कि हमारा सीट थी, चलो मैं तुमको इससे और आसानी से बताती हूँ एक चीज करके. सो कैन यू सी माई व्हाइट बोर्ड? ओके, so let's say party A and party B. This party is from Indonesia this party is from Malaysia, and seat is in Singapore seat, and procedural law कहाँ का होगा? प्रोसीजरल लॉ बाय डिफॉल्ट सिंगापुर होगा। सब्सटेंटिव लॉ कहाँ का था हमारा? लंदन। आर्बिट्रेटर कहाँ का था हमारा? इंडिया। इरम मैडम। एंड द लॉ एप्लीकेबल टू आर्बिट्रेशन एग्रीमेंट इज हांगकांग। ठीक है। नाउ लेट्स से this award is the national or baby or citizen of Singapore. Now this person understood that ये मलेशियन के अगेंस्ट में आता है, and this Indonesian person understood that the Malaysian person has their asset in, let's say, in USA and in Dubai. Where they will go for enforcement? Where they will go for enforcement? So can they go simultaneously together in both the place USA and Dubai? क्या वो एक साथ दोनों जगह पे जा सकते हैं? हाँ या ना? हाँ, तो वो एक साथ दोनों जगह पे भी इन्फोर्समेंट कर सकते हैं। ठीक है। अब क्या कंडीशन होनी चाहिए इन्फोर्समेंट के लिए? कि जहां पे ये बनाया गया है सीट, ये भी किसकी? न्यूयॉर्क कन्वेंशन की सिग्नेटरी हो, और यूएस भी न्यूयॉर्क कन्वेंशन का सिग्नेटरी हो, एंड दुबई भी न्यूयॉर्क कन्वेंशन का सिग्नेटरी हो। समझ में आ गई बात? सो दीज कंट्री शुड बी सिग्नेटरी टू न्यूयॉर्क कन्वेंशन। नाउ let's say if London is not necessary, it should be, but the seat and the place where you are going, that should be the seat for the convention. ठीक है। अब यहाँ पे ये मान लीजिए कि ये यूएस में दुबई में आता है। ठीक है। किस लॉ से दुबई में इन्फोर्समेंट होगा? Under which law? Which should be the procedural law? Which should be the procedural law for the enforcement? Arbitration Act. Very good. So Arbitration Act Dubai ka enforcement hoga. If suppose they will be going for the US, then it will be US arbitration, but through New York Convention. That is why, if it is through New York Convention, that means this country should follow New York Convention. That means uniformity आ गई ना अपने आप, by default uniformity आ गई। अब जो मैं आपको और बहुत इंपॉर्टेंट बात बताने जा रही हूँ, वो बहुत इंपॉर्टेंट है, थोड़ी सी एडवांस है लेकिन बहुत इंपॉर्टेंट है। अगर मान लीजिए दुबई में हम इन्फोर्समेंट करने जा रहे हैं और सीट सिंगापुर में थी, ठीक है। अब जो इन्फोर्समेंट करने यहाँ पर हम आते हैं, तो एक छोटी सी एक क्लॉज न्यूयॉर्क कन्वेंशन में है जो कहता है रेसिप्रोसिटी को, दैट टॉक्स अबाउट रेसिप्रोसिटी। लेट्स से अगर इन दोनों कंट्री में रेसिप्रोसिटी नहीं होगा, तो चाहे वो 174 कंट्रीज हो, अगर इन दोनों का रेसिप्रोकल अरेंजमेंट होना मस्ट है। एक्सक्लूसिव भी कर सकते हैं और रेसिप्रोकल अरेंजमेंट भी हो सकता है। तो इंडिया का 51-52 कंट्री के साथ रेसिप्रोकल अरेंजमेंट है, ऑल्दो वी हैव 174 कंट्रीज इन द न्यूयॉर्क कन्वेंशन, वी हैव ओनली 51 कंट्रीज परमिशन जिसके साथ हम इन्फोर्समेंट करेंगे। अब मान लीजिए इन दोनों कंट्री में रेसिप्रोसिटी नहीं है, सिंगापुर में एंड दुबई में रेसिप्रोकल अरेंजमेंट ही नहीं है। इसका मतलब यह है कि Mahin, if I say, because I understand my time is not permitting me to go ahead, but I want this to be understood by all of you, because ये बहुत important चीज है। और ये 4 चीजें समझना इंटरनेशनल कमर्शियल आर्बिट्रेशन में बहुत इंपॉर्टेंट है। आपका सीट, आपका इन्फोर्समेंट बाय न्यूयॉर्क कन्वेंशन, आपका लॉ, दिस इज प्रोसीजरल लॉ, सब्सटेंटिव लॉ एप्लीकेबल टू कमर्शियल टू आर्बिट्रेशन एग्रीमेंट, एंड थर्ड इज अबाउट द इन्फोर्सेबिलिटी मैकेनिज्म। सो आप कहते हो कि 174 कंट्रीज जो है वो सिग्नेटरी है न्यूयॉर्क कन्वेंशन के, और इसीलिए जो है वो किसी भी कंट्री में अगर आपने अवार्ड जो है वो आप इन्फोर्समेंट के लिए ले जा सकते हो, आप यूएस भी ला सकते हो, आप दुबई भी ला सकते हो, कीनिया है तो कीनिया में भी जा सकते हो, लेकिन वो न्यूयॉर्क कन्वेंशन का सिग्नेटरी होना चाहिए। दैट इज द ओनली थिंग, दिस इज व्हाट वी फील। लेकिन जब आप न्यूयॉर्क कन्वेंशन को पढ़ना शुरू करोगे, उसमें आर्टिकल 10 है। आर्टिकल 10 ये कहता है कि भाई अगर आप सिग्नेटरी भी हो तब भी एक कंट्री के पास ये राइट है कि वो दूसरी कंट्री को ब्लॉक करे मेरी कंट्री में आकर इन्फोर्समेंट कराने के लिए। मान लीजिए कोई पाकिस्तान का या हिंदुस्तान की कोई ऐसी कंट्री है जिसके साथ पॉलिटिकल कंडीशन हमारी सही नहीं है, अब हम ये चाहते हैं कि वहां पे जो भी कुछ हुआ, जैसे कनाइवेंस में दो लोगों ने आर्बिट्रेशन कर लिया, अब वो इन्फोर्समेंट के लिए यहाँ पर आ रहा है, हम तो नहीं आने देंगे इन्फोर्समेंट के लिए यहाँ पर। या किसी ने कहीं पर किया, आप कह रहे बांग्लादेश के लोगों को हम नहीं आने देंगे अपने, हमारे पॉलिटिकल टाइज अच्छी नहीं है। तो उसी तरीके से आपको ये देखना पड़ेगा कि आर्टिकल 10 न्यूयॉर्क कन्वेंशन प्रोवाइड्स द रेसिप्रोकल अरेंजमेंट, इट प्रोवाइड रेसिप्रोसिटी। इफ you have no idea that whether Dubai has a reciprocal arrangement with Singapore or not, आपने बड़े खुश होकर सिंगापुर का सीट को समझ लिया, लेकिन आपने इन्फोर्सिबिलिटी लॉ को नहीं समझा एंड आपने न्यूयॉर्क कन्वेंशन को टोटली नहीं समझा, then again you will fail, you will never able to get the result of that arbitral award, it will be just a piece of paper. India and Dubai has no reciprocal arrangement, and many people they feel that Dubai is now becoming the hub of arbitration, और वो दुबई में सीट फिक्स कर देते हैं। जब वहां पे सीट फिक्स हो गई तो अगर वो इंडिया में उसका एसेट है और इंडिया में इन्फोर्समेंट कराने के लिए they can't come to India for the enforcement because there is no reciprocal arrangement. Abhi recently India has signed a bilateral treaty with UAE, but how much effective it is with regard to the enforcement mechanism, that is not sure so far. तो आप मेरी बात को समझिए कि अगर हमने इन्फोर्सिबिलिटी को ही नहीं देखा इंटरनेशनल में, हमने सिर्फ प्रोसीजरल लॉ एंड सब्स्टेंटिव लॉ देख के हमने बड़ा सा सेलेक्ट कर लिया, बिकॉज वी हैव चॉइस, वी कैन सेलेक्ट, we selected London, we selected this, but we failed to select the seat which is effectively possible that this person has asset in those country, and tomorrow if I have to go for the expropriation or if I have to go to those country for getting the asset or execution or attachment of the asset, but उस country के साथ seat का arrangement नहीं है reciprocal, this will be a very difficult situation for all the people. Are you getting my point? So this is what I wanted to tell you. These are the important aspects. So first is understanding, a clear understanding about international commercial arbitration, seat based classification and nationality based classification. Second thing is that if we are entering into it, we should know the benefit what we have in the domestic arbitration, that also definitely will have will flow for the international commercial arbitration. But majorly it is like a two border dispute or the cross border disputes in those countries. If suppose you need to have a reciprocal if you need to have a enforcement mechanism, so by arbitration it will be easy to enforce the arbitral award rather than the enforcement of the judgment. So that is why people now, they have business people, they want to have an arbitration in that community. That is second thing. Third thing is that if they are entering into this and they want to enforce it, the enforcement mechanism can be supported by the New York Convention. So New York Convention is is very helpful instrument in the international commercial arbitration. That is third thing. And if suppose you are going into this regime, then 2 or 3 things are very important. One thing is that the arbitration agreement is a separate contract altogether. It has a doctrine of separability, right? So whatever the main principal contract terms, arbitration agreement terms are considered to be the independent terms or the separate terms independent to the principal contract. And that is what it is called, doctrine of separability. If doctrine of separability means that is a separate contract. If it is a separate contract, you can designate a separate law together. If you designate a separate law altogether, that means it has a separate legal existence also. So that means one thing, separability. Second thing is that you need to understand the procedural law. Procedural law is a law of arbitration. It is also known as lex flori. It's also known as curial laws. Second thing is substantive law. Substantive law is the part of the how the contract will be governed or the governing law of the contract. It is called applicable laws. It is called governing law of the contract as well, or the law of the contract. And then you have a third law, that is the law applicable to arbitration agreement. After these three things, you need to understand that how the enforcement or enforceability can be affected. Suppose if the country where you are going to enforce the arbitration and the country where you have rendered the award have a kind of reciprocal arrangement also. It is not enough that if all the countries are signatory, that is not enough. Beyond that, there should be a reciprocal arrangement. And the fourth thing is institution. I am from APCAM, that is Asia Pacific Center for Arbitration and Mediation. This is an institution. So institutional rules are also something which is very, very important to understand when you are dealing with the international commercial arbitration. ICC. ICC is international arbitration institution, which is now more than 100 years and has very robust mechanism. If you see LCI, London Court of International Arbitration, that is also a very good institution, and AIAC, that is Kuala Lumpur Center. So we have every country has good centers, you know, SIAC, Singapore International Arbitration Center. So these are the centers which provide a platform to come and resolve the dispute, and they seamlessly they conduct the arbitration. आपको वहाँ पे arbitrators का panel मिलेगा, आपको वहाँ पे rules मिलेंगे, आपको वहाँ पे administration होगा आपके arbitration का. So that is how the rules are also very important. तो एक किसी भी international case में, in the last, let me sum up in this manner, किसी भी international arbitration में, how you can proceed is you can select any person as an arbitrator. Let's say Indonesia, Malaysia. Arbitrator from India. Can be done? Yes. Seat, Singapore. Can be done? Yes. Law of procedure. कहाँ का होगा? कहीं का भी ले सकते हैं? जल्दी बताओ बेटा. कहीं का भी ले सकते हैं? कहाँ का लगेगा? सीट. सीट का लगेगा. शाबाश. तो ये सीट का लगेगा. सीट कहाँ की थी हमारी? सिंगापुर. तो सिंगापुर की सीट होगी और सिंगापुर का ही प्रोसीजरल लॉ, लेकिन आर्बिट्रेशन एक्ट वहीं का लगेगा. और हमारा सब्सटेंटिव लॉ हमारा लंदन का हो गया. रूल्स हमने ले लिए आईसीसी के. क्या हम ले सकते हैं? कैन वी डू दैट? वी कैन डू दैट. लॉ एप्लीकेबल टू आर्बिट्रेशन एग्रीमेंट हमने कहा हांगकांग का हो गया. क्या हम कर सकते हैं? So that is how, you know, in international commercial arbitration, it is like a complete tailor-made suit. हमने कपड़ा लिया पाकिस्तान से, बहुत अच्छा मिलता है, ठीक है, किसका होता है वो, मारिया का ठीक है. हमें मालूम पड़ा दुबई में मुझे स्टिच होता है, वहां से स्टिच कराया. हमको मालूम पड़ता है कि इस पे थोड़ी सी डिटेलिंग जो होगी वो हम इंडिया से करा सकते हैं. हमको मालूम पड़ता है कि इसको हम थ्रू यहाँ से उसको हम पैकिंग वहाँ पे बहुत अच्छी होती है, उसकी पैकेजिंग हम वहाँ से करा सकते हैं. सो ऑल दोज थिंग्स यू कैन डू इन आर्बिट्रेशन. सो दैट इज ऑल पॉसिबिलिटी एंड ऑल दीज थिंग्स आर पॉसिबल इन आर्बिट्रेशन. एंड वंस इट कम्स टू करियर, सो बिलीव मी, it's so easy, so simple to make your career in arbitration, because there are not much people, still there are not much people who are dominantly seen or visible in arbitration and mediation. Both are upcoming areas, both are not very common, and both are not very common in India and Pakistan. If you start it, if you start going to places, if you go for LLM to, you know, any of the place, if you start involving with the centers, if you start involving with the moot competitions, writing and reading and blogging, believe me, you can be the leader. If I could do it, being, you know, from that kind of places and all, so why you can't do it? जब हमने किया था तब तो सोशल मीडिया की कोई पावर नहीं थी, सोशल मीडिया नहीं था, बहुत मुश्किल से हुआ था हम लोगों ने जब किया था. आपके पास सब कुछ है, so you people can do it. So that is what the career aspect. You can be arbitrator, you can be arbitration counsel, you can be tribunal secretary, you can be in the administration, you can be legal counsel in an institution, you can, you know, you can be you know, in academia, and there are multiple things. The important thing is, after all, in the end, I would like to say that all of you need to have a mentor. So that is the must thing, that you should be having a mentor. And the second thing is you should take membership of different institutions. And उसके भी ऊपर भाई तुम्हारा नेटवर्क बहुत इंपॉर्टेंट है, बहुत इंपॉर्टेंट है. Your network is more important than your work. And for that reason, please be on LinkedIn. हम अदनान को LinkedIn से जानते हैं, वरना तो कहाँ हम बैठे हुए कहाँ अदनान बैठे। So that is how you know your LinkedIn is more important and your network is more important than your work. Build network, connect रहो और देखो कितनी अपॉर्चुनिटीज आपको मिलेंगी. We are missing opportunities if we are not on LinkedIn. So my appeal to all of you, my suggestion to all of you, beside what this sessions we are you people are doing रात के 10:30 बजे तक 11 बजे तक आप लोग कर रहे हो, so this shows the commitment. This shows the commitment of Adnan and Khansa and Ehsan that they have brought this kind of platform for all of you. How many people think about it? How many people think about it? आप लोगों के लिए सोचा इन लोगों ने. तो एक तो ये प्लेटफॉर्म हुआ. दूसरी चीज ये आपको मेंटर की बहुत सख्त जरूरत है. एक मेंटर होना चाहिए. उसके बाद में आप इस चीज को यहाँ ना छोड़िएगा. ये बिगनिंग है आप लोगों के लिए. यहाँ से आगे बढ़ना है. ठीक है. और ग्लोबल प्रोफेशन है, लिबरेट जुरिस्डिक्शन, यूनिफॉर्मिटी है, बहुत आसान है. ठीक है. So with this, if Adnan, I think I have taken almost 1 hour and 19 minutes. So this is very difficult for me to stop, early. So
Thank you very much, ma'am. You could speak for the next 24 hours and we'd still be listening with the same enthusiasm.
I am sure it will be a boring thing in 24 hours.
I beg to differ there. But thank you very much for such an amazing session. These people are lucky because when it was also my time, like 4 years back, we did not have experts like you accessible in Pakistan. Now we have such experts जिनका मतलब 20 साल का तजर्बा आपने हमें 1 घंटे के अंदर sum up करके हमारे लिए, for me as well, attending this session has been so enlightening. So we are so grateful to you for that. And I know you've had a long day with the competition, yet you took out time to be here till 11:30 p.m. Indian time. So we are really, really grateful to you. And Essen, over to you.
Yeah, thank you so much, ma'am. It was very insightful session, and obviously very engaging. And you can see the comments. हमारी audience भी जो है same perspective रखती है.
Audience
So,
बहुत generous है आपकी. I must say.
Thank you so much for taking out time out of your busy schedule. So it was an absolute pleasure to learn from you. Thank you so much, ma'am.
Thank you so much.
So now we will move towards the second session that will be delivered by Ms. Kritika. So a formal introduction, if I may use Ms. Kritika. We have a very right person to discuss about the international commercial arbitration rules with us today. Thank you so much, ma'am, for taking out time. And as Saradhan already mentioned, that you had a mediation competition going on, and despite of that, you took time out of your busy schedule. Thank you so much for that. So, as of introduction, Ms. Kritika she has represented her campus, that is campus of Law Center at the University of Delhi at Vis Moot in 2023. And it was their, we can say, very significant achievement that they were ranked 15th number, 15 number out of 374 teams worldwide. पूरी दुनिया में से जो है इनका सिर्फ 74 teams है, 15 number था. That's a quite significant achievement of their team. In addition to that, Ms. Kritika also received an honorable mention award for the best speaker at Vis Moot. Apart from that, she has also participated in Sri Lanka Pre-moot, whereby they came victorious, as well as she received the best speaker award. So I believe with that, you would know that we are a very fit person for this session. And with that, thank you so much, ma'am. Over to you.
Hello everyone, am I audible? All right, so first of all, a little correction. I was not the best speaker. I was the runner-up at the Pre-moot Sri Lanka. The winner was Ishita Keria from IT University in Delhi. But other than that, first of all, thank you so much for this beautiful introduction. And for all of you must know that all of these things that you're talking about would have not been possible without Ghulam. He has been our biggest cheerleader throughout the journey, and given that he is here for all of you arranging all these sessions, you're very lucky to have him. And yeah, that's And we have been very grateful to him, and I'm sure that he's doing great for all of you as well. Now, coming to the topic at hand. So I would be discussing about the international commercial arbitration moot court competitions that go throughout the world, I'll definitely be talking about the Willem C. Vis Moot. But other than that, I'll be talking about 2 or 3 other moots as well to give you a basic idea of what other competitions that you can take part in. So I have a small presentation with me. So if he could present it for me, I'll not be able to do it right now. Yes, great. So first of all, before I explain it to you that exactly why we, before I explain you about the competitions, I think it's very important for you to understand that exactly why is it that we need these competitions. So first of all, when you are studying at law school, what you're studying at law school is extremely different from what you actually do when you start practicing law. And moot court competitions act like a bridge between this, act like a bridge for this whole gap. So I think for somebody who wants to be a part, who wants to practice law, should definitely take part in one or the other moot court competitions to understand the practical application of what you're learning at law school. And secondly, it improves your analytical skills. For example, when we read about a particular law, for example, right now, Iram Majid ma'am, she told you so much about international arbitration. But what use is it if you don't get to apply it in practical life? So moot court competitions help you there, and they improve your analytical skills as well as advocacy in general. And then I think the most important part is that it allows you to have a boost if you want an international career. For somebody who wants an international career in a longer run, I think these competitions such as Willem C. Vis Moot especially act like an amazing opportunity. So as and when I'll discuss throughout the presentation, you'll be able to understand exactly why am I saying all of this. So if we can have the next slide. Right. So first of all, we'll be talking about the Willem C. International Commercial Arbitration Moot. And this is a moot court competition that takes place in 2 places. That is one in Vienna, and the second one is in Hong Kong. So Willem C. Vis Moot is a competition that helps you in understanding international commercial law and the process of international commercial arbitration. So why this moot is important? It's important because it's actually very close to what it actually brings you very close to what an actual arbitration process is. So it helps you, so it helps you in understanding the process of arbitration from a very close perspective. So when it comes to the competition, it takes place in 2 places, as I've already told. One is in Vienna, in Austria, and second version takes place in Hong Kong. If we may have the next slide. Now the moot court problem in this particular moot revolves around, of course, the commercial laws. At the same time, it involves, usually the problem is based in such a way that there's a claim made by a claimant and there's a response. There are different exhibits and all of these. Basically, a case file is provided to you of a commercial dispute. That commercial dispute usually covers laws such as unit law principles and CISG, and the procedural part, it contains ICC rules or PCA rules, and all these together form and make a problem. Now, these problems are divided. That is, this case file is divided into 2 parts. One is the procedural law, and second is the substantive law. When we talk about the procedural law, I think Iram ma'am has already talked a lot about it. It's about the applicability of rules, ICC rules or PCA rules or whatever rules that are governing that problem. On the other hand, substantive law is where the CISG and unit law principles, all of these apply. So these are the 2 parts of the moot, and every year the problem is based in a similar manner. Now coming to the participation, coming towards the participation, first of all, the best part about the Vis Moot is that there are no qualifying grounds for this moot. For example, there are other moots like Nelson Mandela and all of these that basically have national rounds before you can actually go and participate in these moots. However, when it comes to the Vis Moot, there's no qualification rounds. Every university of this world, that is, every recognized university in this world, can send a team directly to either Vienna or Hong Kong. So I think that is the most important part, that you directly get to go there and network with people. Now, I have been told specifically that Pakistan holds national rounds, but I think it's very important to clarify it right here that those national rounds are only for the purpose of deciding question of sponsorship. It does not mean that if you are not able to win that particular national round, or if you're not able to qualify to the semis or the finals, it does not mean that you cannot go to Vienna. Your team can still go to Vienna. The only difference is about the sponsorship. So that's one thing I was told to clarify. And I think it's a very important point for all of you to note, all those who are based in Pakistan. But other than that, every recognized university can send one team. Now, when it comes to the phases of moot, it's divided into two parts. First is the written phase, and second is the arguments, that is the oral phase. Can we have the next slide? Yes. So now this map shows you the timeline for the moot. So the whole process, that is the whole Vis Moot, it takes place through a period of about 7 to 8 long months. It starts somewhere in the month of October, and it goes up to the month of April. So it's a very long commitment. So it is divided, as I said, it's divided into two phases. So the first step is that the release of the problem. It is usually in the first or second week of October, and as I noted, it's 11th of October 2024 for this particular session. Now the second phase is that you go through that whole problem and see if you have any questions, and if there are certain problems or clarifications that you want to seek. For that, the deadline this year would be 1st of November 2024. So basically, when you register your team online, you get an opportunity to file the questions or clarifications through their portal. So that is what the deadline for clarification stands for. After that, it's you submit your registration form finally, and then comes the most important stage, that is the submission of your memorandum for claimants. This is usually in the month of December. This year it's 12th of December. And before I can, I'll get into the memorandum part later. Let's just get over with the timeline first. After you are done submitting your memorandum for claimants, the next step is filling of the registration fees, which is about 700 to 800 euros. I just checked. I think when I participated, it was 700 euros, but I think it has been increased to 800 euros. Moving on to the next step is the memorandum for respondents. So basically, you get about 1 to 2 month period between your claimant memorandum and your respondent memorandum. So that's usually at the end of January, and this year it's 30th of January 2025. And then finally, once you are done with the written part of the submission, the second phase of the competition begins, which is the oral rounds. Now, the oral rounds finally take place in Vienna, usually in the month of April. However, before you do that, there are a lot of other phases, such as the pre-moots and the practice rounds, that take place before you finally reach Vienna. If we can have the next slide. Also, before I proceed, is there any questions until now? Okay, right. So this is the timeline for Vis East. I'll be coming to this later. Can we have the next slide? Yeah, the next slide. Yes, so now this is the phase I want to talk about. Once you are done with your written submissions, that is, once you're done with the written memorandums, now you come to the practice rounds. And before I show you the practice rounds, I want to share with you. Oh wait, I'll do that at the end. I'm so sorry. Yeah. So So now coming to the practice rounds. So now when you go for the Vis Moot, you have to realize that it's a huge competition. So just practicing within your team or just practicing a few times will not help you in achieving your goal over there. So what you need to do is that you practice with teams all across the globe. Now the question is how you do it. So for us, we set up an Instagram page. If you can have the next slide. So this is what our Instagram page looked like. We set up a Vis Moot page for our particular university, and we put pictures and posts introducing all the members of our team. Now, once we set up this page, we started following teams from all across the globe. So basically, every single team that participates in the Vis Moot usually has a similar Instagram page set up. So once that is done, we started to follow teams from all across the globe, and we started to request them for a practice session. So basically what we did was that we set up practice sessions with different teams from all across the globe, such as the team of University of Vienna, or team from Charles University, or teams from University of Mainz. All of these universities that are placed all across the globe used to set up one practice round with all of us, and we would do a full run of the entire pleadings. That is, we would invite arbitrators, and then we would do a full run of the entire pleadings. So basically what it does is it gives you an experience of what is going to happen in Vienna. So what we would do, we would invite an arbitrator. I would have my team, that is me and my other colleague, that is my other counsel. The other team would also come with 2 counsels, and we would then have a full run of the entire pleading to give us the idea of the kind of arguments the other teams brings and exactly how to respond to them, and all of these small parts that we get to learn. Now, the reason why we need to do it is that it helps you build a network even before you go to Vienna. So when you interact with people from different teams, you are able to understand the culture of Vis Moot. So you're able to understand exactly, you don't feel alienated when you, for example, if you already have met about 10 to 12 teams from all across the globe, when you finally go to Vienna, you're able to mix into the crowd, you're able to understand exactly how to respond to the entire cultural change. So all of these, okay, right. So हम लोगों ने क्या किया था, हम लोग जब भी हम किसी टीम के साथ इंटरैक्ट करते थे, फॉर एग्जांपल व्हेनेवर वी यूज्ड टू इंटरैक्ट विद से यूनिवर्सिटी ऑफ वियना, हम लोग सिर्फ प्लीडिंग्स नहीं करते थे, वी यूज्ड टू टॉक अबाउट अदर थिंग्स एज वेल. सो जब हम और चीजों के बारे में बात करते थे, इट एक्चुअली बिल्ट अ नेटवर्क, एंड उससे ये होता था कि सामने वाली टीम को हम याद रह जाते थे. सो दैट इज व्हाट दीज पेजेस ऑनलाइन, दैट इज इंस्टाग्राम पे पेज सेटअप करने से ये सब चीजों में हेल्प मिलती है. सो आई वुड हाईली सजेस्ट दैट whoever forms a team and decides to go to Vienna, ये एक चीज है जो डेफिनेटली सबको ट्राई करनी चाहिए. Now, other than the practice sessions, एक बहुत important चीज होती है, which is the pre-moots. So, can we have the next slide? Right. So, pre-moots होता है, it basically gives you a stimulation. एक तरीके से आपको अलाउ करता है ये in person experience करने के लिए कि आप कैसे वियना में परफॉर्म करोगे. So I'll give you an example. So till now we have discussed कि हमारा जो first phase होता है, it is the written phase, and the second phase is the oral rounds, that is arguments phase. तो second round में जब आप वियना जाते हो, your rounds are divided into 4 to 5 parts. पहला पार्ट होता है कि आपके जनरल राउंड्स होते हैं. You have 4 general rounds where every team that participates get to participate in 4 general rounds. जब आप चारों जनरल राउंड्स में पार्टिसिपेट कर लेते हैं, उसके बाद टॉप 64 टीम सेलेक्ट होती है. Now these top 64 teams go into the rounds of elimination. ऐसे करते करते नेक्स्ट राउंड में 32 टीम्स जाती हैं, उससे नेक्स्ट राउंड में 16 टीम्स जाती हैं, उससे नेक्स्ट राउंड में 8 टीम्स जाती है, एंड देन सेमीफाइनल्स एंड फाइनल्स टेक प्लेस. सो एक पूरा ये प्रोसेस है जो विज मूट के ओरल राउंड्स में होता है इन वियना. तो अब ये जो पूरा प्रोसेस है इसको रेप्लिकेट करते हैं प्री मूट्स. सो इन प्री मूट्स आपको रिटन फेज नहीं करना होता, आपको सिर्फ ओरल फेज के लिए प्रैक्टिस करने का टाइम मिलता है. फॉर एग्जाम्पल लेट्स से हम for example, my team got to attend the Prague pre-moot. So what we did, we went to Prague, और हमारे जैसे 16 टीम्स वहाँ पे आई, I think 16 or 20 teams that came there और वहाँ पर आई, and वहाँ पर everybody did exactly what happens in Vienna. हम सब ने 4 जनरल राउंड्स करे, उसके बाद हम सब में से कट ऑफ हुआ, टॉप 4 टीम्स निकली, एंड फिर 4 टीम्स में सेमीफाइनल्स एंड फाइनल्स, and then one team was declared a winner. So basically, Vis Moot का एक छोटा version होता है pre-moot, because it's based on the same problem. जिस problem पे आपका Vis Moot based है, उसी problem पे आपका pre-moot based होगा. So it is basically like a practice round in a very real setting. So when you get to do that, आप वहाँ पे arbitrators से मिलते हो जो actually Vis Moot में भी arbitrate करते हैं. तो वो जिस तरह के questions आपसे पूछते हैं, उन सबसे आपको समझ में आता है कि जब आप विज मूट के लिए जाएंगे तो वहां पर आपसे किस तरह के क्वेश्चंस पूछे जाएंगे और आप उनको कैसे हैंडल करेंगे. सो ऑल ऑफ दिस, इन सब चीजों को एक्सपीरियंस करने के लिए आप प्री मूट्स में जाते हो. एंड ये तो हो गई प्रैक्टिकल बात कि आप वहां पर जाते हो और आपको इस तरह का एक्सपीरियंस मिलता है विच हेल्प्स यू इन योर मूट. बट अदर देन दैट, गेटिंग टू पार्टिसिपेट इन प्री मूट्स मीन्स दैट यू गेट टू experience it gives you a very different experience, because you make friends, you make networks, you meet arbitrators who actually help you in your career later on. So ये सब benefits extra होते हैं. However, one thing has to be noted कि pre-moots are not compulsory. मतलब कोई ये मत समझना कि अगर आप pre-moot से पार्ट नहीं लेंगे तो आप वियना नहीं जा सकते हैं या फिर आप वियना या हांगकांग में पार्टिसिपेट नहीं कर सकते हैं. These are only to aid you. These do not mean कि आप इनमें पार्टिसिपेट करे बिना वहां पर अच्छा भी परफॉर्म कर ही नहीं पाएंगे, ऐसा भी कुछ नहीं है. इट्स जस्ट एन एड. It's preferable that you go, but if you do not get disheartened and start thinking that it's something that will affect your performance in Vienna. Now coming to the second point, these pre-moots are both online and offline. So कुछ online pre-moots होते हैं. For example, हमने pre-moot श्रीलंका में पार्ट लिया था online. So we pre-moot Sri Lanka pehle offline. So we were located in Paris, all of us, because we were there for the other pre-moots in person, and we took part in pre-moot of Sri Lanka from there. So these are the opportunities that you can take from your home, and these are the kind of opportunities which you should not miss. So you should keep looking for these online on the Vis Moot website. If we can have the next slide. Yes, so and the second thing is is the pre-moots that are offline. So Gulam told me to add a few pictures from the time when we were there so that you get inspired. Because it was not just about the pre-moot, it was not just about the pleadings, it was about the fun that we had and the friends that we made and the friends that we are still in touch with. So this is the kind of network that you can build if you get the opportunity to go into these pre-moots. I mean, most of the faces that you see here in the picture below, we are still in touch with all of these people. And अगर मुझे कभी कुछ help चाहिए होती है, for example, if I'm looking for something in say Swiss jurisdiction or something related to German laws, I can actually call these people or just message them and ask my doubts about all of these things. So इस तरह का जो आपका network worldwide बनता है, ये सब pre-moots इन चीजों में हेल्प करते हैं. सो इफ यू कैन गेट एन अपॉर्चुनिटी और अगर आपके मीन्स में है, यू शुड डेफिनेटली गो फॉर इट. बट ऑन द अदर हैंड, यस, डेफिनेटली रिमेंबर दैट दीज आर नॉट कंपल्सरी. और अगर आप नहीं चाहते हैं तो इसका मतलब ये नहीं है कि आप वियना में अच्छा परफॉर्म नहीं कर पाएंगे. कमिंग टू द नेक्स्ट स्लाइड. सो बेसिकली आई जस्ट पुट अ स्क्रीनशॉट फॉर यू टू सी कि pre-moots की इंफॉर्मेशन आपको कहाँ मिलेगी. So, जो भी नया pre-moot आता जाता है, अपडेट होता जाता है, वो आपको Vis Moot की pre-moots वाले सेक्शन में मिल जाता है. So they keep updating it. If we can have the next slide, you would see अभी यहाँ पे 3 pre-moots listed है, because ये ही 3 pre-moots अभी अनाउंस हुए. So these actually get updated. यहाँ पे नए moots add होते जाएंगे जैसे जैसे update होते announce होते जाएंगे. They'll keep updating it. So you will have to keep a track of it. So I've just put a screenshot so that you remember the face of the website and you can go and check it for yourself. Now coming to the next. Yeah. So as I was, I skipped the, I remember I skipped the slide on Vis Moot Hong Kong. So basically I did that because I did not want to mix it, but I'll tell it to you right now. Apart from the Vis Moot that takes place in Vienna, there is another form of Vis Moot that takes place in Hong Kong and we call it Vis East. So basically the only difference is the number of teams that come to Hong Kong are lower than what it does in Vienna. Otherwise, the entire structure of the moot, the problem of the moot, the written statement, the written memorandum for claimants, your respondents, arguments, everything is same. The only difference is that the number of teams that come are lesser and your elimination round starts from 32 instead of 64. That is the only difference. And this basically was created to give more opportunity to students who cannot travel as far as to Vienna. So ये basically Asia में Vis Moot का culture promote करने के लिए किया था. So it is identical to Vis Moot. The only difference is the registration fees a little bit here and there, and the timing is different. This moot takes place before Vis Vienna. So basically, if Vis Vienna is in the first week of April, this moot might take place in third week of March. So that is the only difference. So, and one more thing, you can go to both Vis Hong Kong and Vis Vienna. It does not, if you go to one of them, does not mean that you cannot go to the other one. So although what your university does is something I'm not aware of, that if they send one team to Hong Kong and to Vienna separately, that is something Ghulam can, I think, tell you better. So if you would want to intervene, Ghulam.
Yeah, so in Pakistan, there's no as such culture, but generally what happens is कि यूनिवर्सिटीज टीम को डिवाइड कर देती हैं. तो लेट्स से अगर 8 बच्चों ने अप्लाई किया, दे वांट टू, बिकॉज जब आप अप्लाई करते हो इस मूड के लिए, यू हैव अ डॉक्यूमेंट व्हिच यू नीड फ्रॉम द यूनिवर्सिटी व्हिच सेज दैट दे डू नॉट हैव एनी ऑब्जेक्शन ऑन योर पार्टिसिपेशन इन द मूड. तो ये करेंगे कि अगर 8 बच्चों ने अप्लाई किया है, वो 4 को भेज देंगे विज ईस्ट के लिए, 4 को भेज देंगे वो विज वियना के लिए. इससे ये होता है कि दोनों मूड्स में पार्टिसिपेशन हो जाती है. बट अदरवाइज कुछ यूनिवर्सिटीज होती हैं, वो कहती हैं नहीं, हम उन 8 बच्चों को वियना भी भेजेंगे, उन 8 बच्चों को हम हांगकांग भी भेजेंगे, ताकि उनका फिर चांस जरा हायर हो जाता है कि अगर लेट्स से वो हांगकांग में नहीं टॉप 32 के लिए क्वालिफाई करते, मे बी वो वियना में कर जाएं. अगर वियना में कोई अवार्ड नहीं जीतते, शायद वो हांगकांग में जीत जाएं, क्योंकि मूड तो एग्जैक्टली सेम है, बस जियोग्राफिकली इट्स अ बिट डिफरेंट. सो दैट्स हाउ इट हैपेंस.
Right, thank you so much for that input, because in India we usually do not have that distinction. Usually the team that goes to Hong Kong goes to Vienna, and even at my law school there was no such rule that team can go to only one of these. So thank you for clarifying that. Can we have the next? No, wait. Yes, I need to discuss the basic readings. So basically, when you start, so it's just a basic idea for all of those who are interested in Vis Moot and want to see whether Vis Moot is for you or not. You can actually go through these basic readings that I've listed over here on the screen to understand the nature of arbitration and the nature of CISG, that is the substantive law which is applied in this whole problem. So अगर आप एक बार ये रीड करके देखेंगे तो आपको पता चलेगा कि आपका इस पर्टिकुलर मूट में इंटरेस्ट है या नहीं. So this is basically, I've listed them here for that purpose. And even if you are interested, then definitely you should go for these books and read them, because they will help you develop the basic understanding before you start researching. Now coming to the team composition, the minimum number of team members that you need to participate in Vienna is 2. So basically, Ghulam and I can form a team and go. At the same time, there is no upper limit. We can have 4 members, we can have 10 members, we can have 12 members. That is up to you. However, I wouldn't recommend that you have 12 members, but still, it's up to you. There's no upper limit. but the minimum number of people that you need is 2. Now coming to the next slide. So basically, I just summarize the entire, because I think there has been an overload of information regarding the moot. So I'll give a quick recap for you to be able to form any links. So the first thing, the Vis Moot takes place and it starts from the month of October, and the entire process goes up till April. The moot is divided into 2 parts. First is the written submissions, and second is the oral submissions. The written submission again is divided into 2 parts. First is the statement, it's the memorandum for claimants, and the second part is the memorandum for respondents. Once you are done with the first phase of the moot, that is the written part of the moot, you move to the second part of the moot, that is the oral pleadings. You start preparing and practicing for the oral pleadings in the month of, somewhere in the month of February. इसी टाइम पे आप practice rounds करते हैं. You set up your Insta page, you interact with teams, and you start your practice rounds. You do the pre-moots exactly during this phase, क्योंकि pre-moots February में शुरू हो जाते हैं and वो March end तक चलते हैं. So इसके बीच में जो भी portion आपके लिए available है, जिस भी time पे आपकी university आपको भेज सकती है, उसके according आप pre-moots और practice rounds करते हैं इन 2 महीनों में. And once you are prepared, you go to finally either Vienna or Hong Kong, depending upon where your university sends you. Once you reach Vienna, your entire 7 to 8 days are again divided into 2 parts. First part is your general rounds. That is 4 general rounds that every team has to participate into. And the second is the elimination rounds. That is the top 64 and above. So ये 2 parts में आपकी पूरी journey रहती है. At the end of this journey is the award ceremony, which is the slide I skipped earlier, because I wanted to talk about it in the end so that you're able to understand the importance of that slide. Yes, here. So आपके आगे. No, the one that has awards. The next one.
This one?
The next, yes, this one. So आपके elimination rounds जब खत्म हो जाते हैं, that is when your winner is announced. उसके बाद award ceremony होती है. An award ceremony has total 5 awards, which are listed here. First is the Eric E. Bergston Award, which is given to the team that prevails. Other than that, honorable mention for Eric E. Bergston Award is given to all the 64 teams that make it to top 64. The second award is the Martin Domke Award, which is for the best individual speaker. Other than that, about 30 to 40 students out of the entire population that participates gets an honorable mention for the Martin Domke Award. That is the best speaker award. Then you get award for best memorandum, and similarly for claimants and for respondents separately. And then finally, there is one Spirit of the Willem C. Vis Moot Award. And usually people make videos of their journey or something different, and they try to show the Vis spirit in them, and they submit it to the mooting community, and then one winner is announced. So this is something which is not related to your problem and the moot. It is a separate award that goes parallelly throughout. But other than that, there are total 4 awards that I've told you about. Similarly, in Vis East, there are correspondingly similar awards. That is for best team, best speaker, best memorandum for claimants and respondents, along with their honorable mentions. Now coming to the end of the Vis Moot, I just want to discuss one thing that for me, Vis Moot has been life-changing. And I would highly suggest that if it's possible for all of you, that you should definitely give it a shot. At least try to go to this moot. The reason is simple, that first of all, you directly go to Vienna. There are no qualifying rounds. ये सबसे बड़ा benefit है इस moot का. Secondly, you get to plead in front of senior practitioners. So, for example, I am at this point, when I participated in this moot, I was 23 or 24 years old. So उस age में जब मैंने when I got to participate in front of arbitrators who actually sit in ICC or who actually are a part of institutional arbitrations, who are a part of these big institutions, it gives you a lot of exposure. You get to learn a lot. So you're in law school, but you're still ahead of all the students that are there with you. So definitely you should participate in this moot because it gives you the kind of exposure that no other opportunity can give you. Then third thing is networking. As I told you that I have friends all across the globe right now. So I flaunt a lot about this, that, if I need help from somebody in the US, I can quickly just message them on Instagram and I ask for help. For example, recently, one of my friends Indian friend who's living in US, he had a problem related to his phone, that there was some hacking and there were some issues. And I was quickly able to talk to my friend I made on during Vis Moot and ask him about the legal position regarding all of this. So this is just very small example, but you can actually, benefit professionally from the networks that you make. For example, one of the arbitrators who arbitrated one of my rounds offered a pupillage because he liked the way our team performed. So these are the kind of opportunities that you can actually get if you network the right way at Vis Moot. And for example, one of my teammates, Rupal Shah, she was able to become a research assistant with one of the arbitrators who's presently situated in UK. So all of these are if you are able to network and you can actually grab opportunities like these, then I think Vis Moot is the kind of platform you should definitely explore. Then secondly, it will help you with your oral advocacy, written advocacy. These are the general benefits that you'll get. One thing I know for sure, that Vis Moot has changed the trajectory of my career in legal field. So I think this is something you should definitely try. And I think the best part about the Vis Moot is the parties that you have every single night at House Gazelle. This is something that I can never forget. The conversations that you have there, the friends that you make, and the time that you have it's just something that you'll remember for life. So I think Vis Moot is not just a moot, it's like a festival. So everybody who can get a chance should definitely go for it and think about it. And I am sure that, you'll make memories and you'll make friendships that will last throughout your life. So it's not just a professional thing, it's also about your, personality development. So yes, that is something I wanted to end this, conversation about Vis Moot. And also it's very close to my heart. So every time I talk about it, I tend to talk a lot about it. So I'm really sorry for taking this long on just one single moot. Can we have the next slide? So now that we are finally done with the Vis Moot, let's talk about the other moots that are there in the field of international commercial arbitration or arbitration in general. So the second important moot that you can take part in is the cross-examination moot. So when you will actually participate in arbitrations as lawyers in future, you will see that, arbitration has stages and cross-examination is one of the important stages. So the importance of cross-examination is that so basically you need to have a skill set to be able to cross-examine somebody. And that skill set comes with practice. So this one particular moot is that which focuses upon this particular aspect of arbitration, and you should definitely, think about it and explore more about it. So this particular ये जो moot है, ये Sciences Po University in Paris, they host it, and this moot actually takes place in person in Paris. So I think last year it happened online because of the COVID, but after that it has been taking place in person in Paris. So definitely all those who are interested in these kind of topics and problems, that is towards the technical side of the arbitration as well as technical side of law, should definitely explore this one option. Can we have the next slide? Again, this moot is open for all the recognized universities in the world. Secondly, the registration is 300 euros. And once again, you need to have at least 2 people in your team to be able to participate in this moot. There is again no upper limit, but there is a lower limit, that is 2 persons should be there for you to be able to participate in this moot. Secondly, can we have the next slide? Right. So this applies to the Vis Moot as well, that you can have coaches. So coaches help you in understanding the structure of the moot. तो ये जो moots होते हैं they are very bulky, बहुत बड़े moots होते हैं, 7-8 महीने की commitment लेते हैं, तो जरूरी होता है कि आपके पास कोई हो जो आपको गाइड करता रहे हर स्टेप पे. Like for example, when we started our Vis Moot journey, we were very clueless कि ये exactly moot में होता क्या है. हम जब नेशनल मूट से पार्ट लेते हैं यहाँ पर इंडिया में, तो यूजुअली प्रॉब्लम रिलीज होता है हफ्ते भर में, हम एक मेमोरेंडम बनाते हैं एंड देन वी जस्ट गो फॉर द फाइनल राउंड. But Vis Moot is something that actually takes months of your time, so you need to have the right guidance. So उसके लिए coaches की बहुत जरूरत होती है, and Ghulam did that job for us. Really, he did it really well. So all of you should. Of course, having a coach is not compulsory, but you should, in my opinion, have a coach. And coach ढूंढना कोई बहुत मुश्किल चीज नहीं है. You can simply go on LinkedIn. You can reach out to people on LinkedIn, and that is exactly how I met Ghulam. So one of my team members approached Ghulam and asked if he would be willing to coach us. We had a session, and within a session, it was decided that yes, we have Ghulam as our coach. So for both the competitions, that is the cross moot and the Vis Moot, you can have coaches, and you can have as many coaches as you want. You can have 1 coach, you can have 2, 3, 4 coaches, as many as you can find, or as many as you think are optimal for your team. Then the structure, if we talk about the structure of this competition, unlike the Vis Moot, there is no written phase in this competition. So there would be only the oral phase. That is, this moot does not have these 2 phases as we did in Vis Moot. There is only an oral phase, and there are once again 4 general rounds. Depending upon those 4 general rounds, you get into the elimination rounds, and this then again it's proceeds as it does in Vis Moot. Then you get into quarterfinals, semi-finals, and then finals. Can we have the next slide? Right. I just put a screenshot of the website over here so that when you go online and look for the cross moot, you're able to identify which website is it. Rest, all the details related to the case file and all of these, you can find it on this particular website, which is being shown in front of you right now. It's crossmoot.com. Can we have the next slide? The next one. Yes. So this is a virtual moot court competition. For all those who cannot at this point for any reason go to Paris or Vienna or Hong Kong, can actually take part in this moot. It's organized by Mediate Guru, and once again the eligibility is that you can if you like any recognized university in the world can take part in it. So you need to have once again your college's permission and your letter, and that is all you need to be able to participate in this moot. Once again, I've put the screenshot of the website so that you are able to go and look for it online. This year, this moot is being organized from 17th till 20th of October. So I think the process regarding the registration and all of this, in the release of the problem and all of that has already been displayed on the website. So if you can we have the next slide? Yes, so it's given here. So the problem has already been released and the registration has also already begun. So if you are interested in it, I think it's time that you form a team and decide if you want to take part on it or not. And you can once again visit the website for the greater details of this competition that is regarding you can download the problem which has already been released in this particular moot. Can we have the next slide? Yes. So these are certain aspects that I should cover that I think would be, these are हो सकता है बहुतों के दिमाग में हो ये question, so it's better we discuss it. In India, when we talk about the sponsorships, हम लोग यूजुअली लॉ फर्म्स को अप्रोच करते हैं और प्रैक्टिशनर्स को अप्रोच करते हैं. However, I have been told that in Pakistan, the national rounds are also conducted for sponsorship. So, regarding that, you can explore that option. Secondly, you can approach practitioners and you can approach law firms through LinkedIn. You can approach them directly. You can approach them through the websites or the email IDs. Secondly, the travel cost depends upon certain factors. For example, हमारी टीम ने 4 ऑफलाइन प्रीमूट्स अटेम्प्ट किए थे along with Vienna. So हमारा जो cost था, it was about 3 lakhs Indian rupees. So if we convert it, it would come somewhere around $3,000 to $4,000. So that is what we spent for 45 days. So अगर आप इसको convert करते हैं, if you just decide on attending one particular phase of the moot, that is the Vis Moot in Vienna, then the cost would be lower than about 1 lakh rupees. That is 1 lakh Indian rupees. So you can convert it accordingly. And this is for one participant, like under 1 lakh rupees, Indian rupees for one particular participant. And I think Ghulam has put in the conversion in your in the chat box, so you can check that. Now, I think I've given so much information regarding different moots. It's very important for you to decide first that exactly what is the kind of exposure that all of you want. So, अगर आप लोगों को interest है arbitration का पूरा process जानने में, then I think Vis Moot is the best option. And the first step that takes place when you decide कि आपको क्या moot करना है is the formation of your team. Team form करना भी एक कला है. It takes a lot of efforts to find the right kind of people जिनके साथ आप काम कर सकते हैं. It is very important कि आपकी टीम के साथ आपकी थोड़ी रैपो हो, नहीं तो वो पूरा महाभारत का युद्ध बन जाएगा and you'll not be able to work. So this is a skill that this is something you should be very careful about. So when you're forming a team, you should make sure that you have hardworking people and you have people who are have a similar mindset as you do and are on a similar wavelength when it comes to working hard, because this moot will require a lot of commitment. So you should know that if you are willing to put in 3 to 4 hours every day for the next 8 months, your teammates are also willing to do the same. Because अगर आप वहाँ जा रहे हो तो आपको वहाँ पे जाकर बेस्ट परफॉर्म करना है, ताकि आप वहाँ पे जा रहे हो इतना खर्चा करके, इतनी मेहनत करके, तो आप वहाँ से रिटर्न्स लेकर आओ in terms of not only awards but in terms of experience. So when you'll be able to do that only if you have the right kind of people with you. So you need to focus on that as well. एक बार आप अपना टीम फाइनलाइज कर लेते हैं, उसके बाद the next step, very important step, is finding a coach. I've already told you, you can reach out to people on LinkedIn. What you can do is you can actually look for people who have already participated in Vis Moot. For example, last year, one of my ex-teammates, that is Rupal Shah, she was a coach for an Indian team. So what you can do is you can reach out to people who have already participated in Vis Moot and ask them if they are willing to coach you, or if they are willing to refer you to somebody who's willing to coach you. So धीरे धीरे करके आप अगर 50 लोग, so जब हम लोग कोच ढूंढ रहे थे, हमने किया था डिसाइड कि हम लोग डेली 10 लोगों को मैसेज करेंगे. We'll message 10 people every day, and whoever will respond, we'll start engaging them accordingly. But we were lucky enough कि हमें उतने ज़्यादा messages भेजने नहीं पड़े. But this is what you can try, that you can start reaching out to people and talk to them and ask them if they know somebody or if they're themselves willing to coach you. You can create a profile of your team. For example, what a lot of people do is that they would create a profile in a PPT or in a PDF file or in a Word file where they will mention every single member of their team and they will mention the achievements of their team. So what happens is that you are able to show your, for example, if you're approaching me कि आप हमारी टीम को कोच करिए, ये हमारी टीम है और ये इसके लोग हैं और ये इन्होंने काम किया हुआ है. So it helps me it gives me an idea कि मैं आपकी टीम को अगर कोच करती हूँ तो आपकी तरफ से कितना कमिटमेंट रहेगा और आप कितना ऑलरेडी एक्सपीरियंस्ड है. So this will help you. You can try this thing. Then secondly, the next step Once you have found your coach, you have formed your team, you get a permission from your university. इंडिया में हमारे साथ ऐसे होता है, फॉर एग्जांपल इन माय यूनिवर्सिटी हम लोग अपनी टीम फॉर्म करने के बाद वी यूज्ड टू हैव एन इंटरनल राउंड. सो फॉर एग्जांपल अगर मैंने 4 लोगों की टीम फॉर्म करी है और कोई और भी टीम है 4 लोगों की जो जाना चाहती है विज मूट में, देन वी वुड हैव एन इंटरनल राउंड within the college and the prevailing team gets to go to the competition. So similar, I'm not aware if the similar process takes place in your university for every move. तो वो तो सबकी यूनिवर्सिटी पे subjectively depend करेगा. So find out the process कि आपकी यूनिवर्सिटी में क्या process है, comply with that and register your team for the Vis Moot. And with that, I think I have already dispensed with all the information that I had. If there are any questions, I can also show you samples of our memorandums if you want at the end. But before that, if anybody has any questions.
Just one question which I would like to ask on behalf of the participants. So you mentioned coaches are essential and everything. How does that engagement look like? If you could tell the teams, like, do you have to pay the coaches? Or is it just for free, or like what's the sort of engagement with the coaches? Asking it for the sake of the participants here.
See, as far as I know, student coaches usually do not ask for remuneration because they're just beginning with their career in the coaching field. For example, we got very lucky because we did not have a lot of money to pay to coaches, and Gulam was ready to coach us for free that year. So we got very lucky. But usually जो professional coaches होते हैं, they do charge some basic amount at times. However, it depends from person to person. Sometimes coaches are willing to coach you for free as well. So that is something you need to talk to your coach well in advance. But usually अगर आप ऐसे सिचुएशन में है कि आप नहीं पे कर सकते कोचेस को, जैसे हम थे जिस टाइम पर, we could have not afforded a coach. But so उस केस में you can approach student coaches. जो स्टूडेंट्स अभी रिसेंटली पार्टिसिपेट करके आए हैं लास्ट ईयर या उससे लास्ट ईयर, अगर आप उन लोगों को अप्रोच करेंगे, दे विल यूजुअली नॉट चार्ज यू बिकॉज दे आर देमसेल्व्स ट्राइंग टू स्टेप इनटू दिस बिजनेस. सो दैट इज समथिंग हाउ यू कैन नेविगेट कि आप अपनी अफोर्डेबिलिटी के हिसाब से और अपने फाइनेंशियल रिसोर्सेज के हिसाब से यू कैन अप्रोच पीपल. Is there anything else?
I think we're good.
Right. Well, I will share with you the memorandums and samples. And other than that, even if you do not get the access to definitely I can. Right. In fact, I have been planning to coach a team with Gulam. So if that does happen, I would consider that, we have done our part of, assisting Gulam in coaching another team. So definitely, yes. And yes, I am sure that, after our team was able to perform good, his business would have, flourished way more than it would have. So I am happy we could do that for him. And even in future, yes, definitely. Even this year, we were planning to coach a team together. So I'm sure I'll be able to. Is there another message? Yes, definitely. I'll share the slides. I think I have already shared it in the Lovitz group. I think Gulam is presenting it, so he already has the access. If there's any other way, if you can think, I can share it with you.
So we will share these slides shortly after the lesson. So please bear with us while we do that.
I can also share with you the samples of memorandum that we made. But other than that, you can actually access the best memorandums for each year on the website of Vis Moot. So if you can go to vismoot.com, you will be able to access उसके कॉर्नर में लिखा होता है प्रीवियस मूव्स. तो वो प्रीवियस मूव्स पे जब क्लिक करेंगे तो उसमें ड्रॉप आउट खुलेगा जिसमें 30th Vis Moot, 31st Vis Moot, 29, 28 सारे आ जाएंगे. तो आप जिस भी मूड को खोलेंगे उस ईयर में जिसने बेस्ट अवार्ड जीता होगा, बेस्ट मेमोरेंडम के अवार्ड जीते होंगे, वो भी वहां पर अवेलेबल होते हैं. सो यू कैन डेफिनेटली गो एंड लुक एट इट फॉर योर अंडरस्टैंडिंग. But other than that, हाँ मैं ये slides share कर दूँगी. I think I've already shared it, but yes, I'll share it again, and Gulam will forward it to all of you. Other than that, if you have any questions, please feel free to message me on LinkedIn. You can find me on LinkedIn as Kritika Singh. And for filter, you can add either Campus Law Center or Chambers of Shashank Garg. You'll be able to find me. And I have shared my LinkedIn profile, like the link to my LinkedIn on the first page of the PPT as well. So you'll be able to find me easily. Feel free to connect there and feel free to ask any questions you'll have. I might be a little slow in answering, but I'll definitely make sure that I do answer. So yeah, that's it from my side.
Amazing. Thank you very much, Kritika, for such an insightful session. Just one thing for the participants, you do not have to be as amazing and have the biggest achievements in the Vis Moot as Kritika to be able to change your trajectory in the Vis Moot. So just to put it out there, अगर आपने Vis Moot में participate किया है, अगर आप 374th नंबर पे भी आए हो, तो भी you are qualified for scholarships because of the Vis Moot. यूरोप में दे इतनी यूनिवर्सिटीज हैं जिनके अंदर स्पेशली एक अलहदा से सेक्शन होता है कि क्या आपने विज मूट में पार्टिसिपेट किया है. दे डोंट आस्क यू whether you got an achievement like Kritika or not. They just ask you किया बस ये लो स्कॉलरशिप. यूनिवर्सिटी ऑफ मियामी इज वन ऑफ द यूनिवर्सिटीज जो कहती है कि भाई अगर आपने विज मूट में किसी भी कैपेसिटी में आर्बिट्रेटर, कोच, स्टूडेंट पार्टिसिपेट किया है, हम अपनी LLM की एप्लीकेशन फी तो वेव ऑफ कर देंगे $75. उसके बाद they give you a scholarship of $20,000 on top of that. So there are multiple universities worldwide who just on the basis of your participation give you scholarships. So if you are planning to do an LLM, this is great option. Then if you are planning to be someone like Kritika, she's working at one of the biggest chambers in India. India के जो ICC, we've been talking about ICC, International Chamber of Commerce. उसके जो India project के chair हैं, she's working with him, right out of law school. So that's how it really changes your entire life there. So thank you very much, Kritika. We really appreciate you taking out the time. I know it's beyond midnight at this point. You had a long day, yet you are here presenting to our students. We're really grateful for that. Thank you very much for joining.
I think that is exactly what the Vis spirit is, because no matter how tired I am, no matter how exhausted I am, when somebody talks to me about the Vis Moot, I get as excited as and even if when a team approaches you, like not just me, I think this apply to every Vis Mootie, that if a team ever approaches you with a problem, you just cannot say no, because that is exactly what the Vis Moot is about. And just adding one more point to what Gulam said, that it's not about winning an award at Vis Moot. Vis Moot में award आए नहीं आए इससे कोई फर्क नहीं पड़ता. फर्क सिर्फ इस बात से पड़ता है कि आप वहां जाने के बाद उस अपॉर्चुनिटी को कैसे यूटिलाइज करते हैं. अगर आप वहां जाके 10 प्रोफेशनल्स के साथ अपनी रैपो बना लेते हैं, उनको आपका चेहरा याद रह जाता है, आप उनके साथ कनेक्ट कर पाते हैं, नेटवर्क कर पाते हैं, दैट इज व्हाट मैटर्स मोर देन गेटिंग एन अवार्ड. अभी मैंने लास्ट ईयर अवार्ड जीता तो अभी सब लोगों को याद है, लेकिन अगले 5 सालों में किसी को याद नहीं रहेगा दैट कि मैंने Vis Moot में कुछ भी अवार्ड जीता था. द ओनली थिंग दैट विल मैटर इज कि मैंने वहां जाके कितने लोगों के साथ कनेक्शन बनाया और अब वो कनेक्शन किस तरह से मेरे करियर में रिफ्लेक्ट हो रहा है. सो दैट इज ऑल दैट मैटर्स. तो अगर आप वहां जाते हैं अवार्ड के चक्कर में, डू नॉट मिस दी पार्टीज और ये सब. मतलब पार्टी इज नॉट जस्ट अबाउट एंजॉइंग, it's about actually socializing and networking as well. So ये opportunities awards के चक्कर में और pleadings के चक्कर में miss मत करना बिल्कुल भी. Like I remember what we would do is that we would plead during the day और फिर रात में हम लोग पार्टी के लिए जाते थे, फिर हम 4 बजे वापस आते थे सब लोग exhausted, और फिर किसी तरह अगले दिन फिर सुबह 8 बजे हम लोग pleadings के लिए जाते थे. So that is how Vis Moot operates. It's like a full festival in Vienna for 7 days. So enjoy that. उसको एंजॉय करिए, सिर्फ अवार्ड्स के लिए मत जाइए, और नेटवर्क करिए जितना ज्यादा आप कर सकते हैं, एंड यू विल रिमेम्बर इट फॉर योर लाइफ टाइम. आई कैन प्रॉमिस यू दैट. सो व्हेन आई जाने से पहले लोग मुझे ऐसा बोलते थे दैट Vis Moot changes your life, and now that I've come back from it, I know it does, and it will do it for everybody and anybody who will participate in it.
Thank you so much, ma'am. Thank you so much for your time, and I know that you have a very hectic day today. और इट कैन बी सीन फ्रॉम द पार्टिसिपेंट्स कि अभी तक जो है रिटेंशन हमारे पास 31 की है, विच मीन्स कि पाकिस्तान के अंदर इस दफ़ा पहली मरतबा ये हुआ था, लाइक इट्स बीन आई थिंक 2 to 3 years के थोड़ा सा ट्रेंड चलने लगा है विज मूट को, और पहली मरतबा पाकिस्तान में इस दफ़ा नेशनल राउंड्स भी हुए थे. सो वी बिलीव दैट दिस इवेंट एंड पर्टिकुलरली दिस सेशन जो है इसने स्टूडेंट्स को इतना अवेयर कर दिया हो गया कि वो अभी जो है मतलब वो एरियाज एक्सेप्ट लाइक रावलपिंडी के इंस्टीट्यूट्स हैं, लाहौर के हैं या इस्लामाबाद के हैं, वो भी दे विल बी एबल की जो है वो अपने बलबूते के ऊपर इंडिपेंडेंटली जो है दे कैन रजिस्टर फॉर दिस काइंड ऑफ कॉम्पिटिशंस. Thank you so much for your time. It was a pleasure having you. Thank you so much, ma'am.
I had an amazing time here too. Thank you so much for having me here. It feels really nice, when you get invited to these events. It just feels very special. So yeah, I also had a great time. Thank you so much. Thank you, Gulam. I'll see you some other time and I'll connect with you on LinkedIn. Thank you. Bye-bye.
Thank you very much.
See you all tomorrow, inshallah.